Now is this mine here? Is this my copy?
Have it Sam.
You got a copy?
Yeah, that's a copy. Karen, who's not coming tonight? John?
Jeff said he would be here.
Okay. Mr. Anderson, indication?
Sir?
You do the indication?
Oh, yeah. Yes, sir.
Can we not text him and ask Jeff and see if he's coming?
Who wasn't it?
Can we not text Jeff and see if he's close?
He's already late. He stopped at something.
Well, he would put his
right
pizza,
when it gets
he
there.
could put pizza back there for us.
Does Joe want a short one or a long one?
You what?
Does Joe want short prayer or a long prayer? Short for
He's big on the short. No, it doesn't. No surveys, no plans.
What's your name? Amber? Nice to meet you, Amber. Which one you here on? Number 2? 2 and 3. Don't hesitate to tell us to slow down or hush up or speak up, okay? We have one board member that we're waiting to arrive. We have 7 members. We have 6 that will be here tonight. We're going to give them a few minutes before we move ahead. Call the meeting in order, so if you would, just bear with us. His microphone is pretty sensitive. I like all of us.
Please don't crackle.
Karen, you want to call him, text him, see where he's at?
And everybody's booing when he walks in.
He don't handle pressure well.
Here he comes. Here he comes. Appreciate you guys waiting.
We're just gonna go to the house if you didn't show up. Yeah,
Adjourn the meeting.
yeah, we're just gonna postpone this thing. At this time, we will call the May 24, 2018 Walton County Zoning Board of Adjustment meeting to order. If you would, please stand as we have the invocation, followed by the Pledge of Allegiance. Mr. Anderson, if you would, lead us in the...
Yes, sir. Let us pray. Heavenly Father, we thank you for all you provide. We thank you for the opportunity to live in this beautiful county of ours and in this great nation. We ask that you be with those who protect us, those who serve in the armed forces, those who protect us globally, as well as those who protect us locally. We ask that you give them strength. We ask that you give their family comfort, strength as well. Heavenly Father, we pray this in your Son's name. We just pray in Jesus' name. Amen.
Allegiance to the flag, United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. You may be seated. We do appreciate all the board members being with us tonight. We do have one board member that's not here. We'd like to give a special thanks to our Secretary, Karen Owens, for the hard work that she does month long making this possible. We appreciate our legal counsel, Mr. Dykes, being with us. All the other planning department personnel, we thank you for creating such a mess for us that we have to come in here and straighten out. We do thank the legal counsel for the county, Ms. Sydney Noyes, for being with us tonight. We have any announcements need to be made at this time, Mr. Dykes?
There are no new developments as far as any of the pending appeals. They're still with Judge Lewis, so we're still waiting on rulings for him, so nothing new to report there. And then I think Matt may have an agenda item.
Yes, sir. We have a request to continue on item number 1 from the applicant.
That's the Rutherford
Yes, sir.
variance request. Motion to continue to the June meeting. Is it the June meeting?
Yes, sir. That would be June 28th.
June 28th.
So moved.
Second?
Second.
All in favor, aye?
Aye. Thank you.
Very good. Before we get started, we will give each and every person here the opportunity to speak before this board tonight. We hope that y'all understand that we don't want to have repetition, but we do want this meeting to move along, make sure everyone's heard. Obviously, we have the issue that is concerned, and we do appreciate everybody coming. With that being said, we ask that each and every person that plans to speak before this board, if you would stand, raise your right hand, and swear that the testimony that you give will be the truth to the best of your knowledge. We would like for you to do that now. So if you would, please stand. Everyone that planned to speak before us tonight, please stand, raise your right hand. Mr. Dykes?
Thank you. Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Okay. And Mr. Chairman, anyone who does plan to speak, so we can have an accurate record, if you will, when you introduce yourself, please spell your last name so the secretary can put that into the minutes.
Very good. I guess we need to go ahead and clarify that we have 7 members. It does take 4 members of this board to confirm a variance or to confirm it or deny it. We have 1 missing. I guess if someone wanted to continue because we have 1 board missing, only 6 of us, it takes 4. Does anyone here want to postpone to another time? Now's the time to let this board know. Did you want a full board? Mr. Shipman?
I'm fine with the 6 that are
Okay, very good. First item been continued. The second item is the San Roy Road variance. Mr. Shipman, I believe that's yours. Is that correct?
Yes, sir.
Are you the one going to do the presentation, or are you going to let Melissa Ward?
I'll be doing the presentation, and Melissa will be correcting me when I'm wrong on various things, and finally tell you
Okay.
about free will.
If you would, come before us and tell us exactly what you're asking for tonight. Item number 2, San Roy Road variance.
Again, for the record, I'm Gary Shipman, Dunlap and Shipman, and I'm appearing on behalf of 187 San Roy Beach Holdings, LLC. We have applied for a variance as to the front setback. And I kind of like to start off by emphasizing what we're not here about. We're not here about an appeal to a building permit. We're here about simply a variance on the front setback. This piece of property, because of the unique nature of it, it is entirely within the coastal protection zone, which means DEP has to issue the building, approve any building permit on the property. The property itself has a 66-foot, well, there is a 66-foot wide county right-of-way that goes across the northern 33 feet of this property and the southern 33 feet of the property immediately to the north. What I'd like to do is go ahead and first, since I guess it hadn't been admitted into evidence, I'd like to go ahead and admit into evidence our application for a variance. And I have an aerial photograph that I'd like to admit in and provide copies to all of you because it'll help you orient as we're talking about the property tonight. So if I could go ahead and do that.
Mr. Dietz, is this going to be applicant Exhibit A?
So, yeah. Well, I just went out. Same time I have a photograph of the exhibit B. And if you can give me,
That also will include, Mr. Dietz, we're going to include the staff report also, right?
Yeah, when staff presents, they usually request that be introduced, so there'll be some additional photos.
I'll be putting it in either one.
Yeah.
While we're getting the application, if I could pass out these aerial photos.
Mr. Shipman, you wanted this as applicant's Exhibit B, correct?
Video too, pass out the application.
And this will be marked as, Mr. Chairman, for the record, as Exhibit A for the applicant.
Exhibit A. So in there.
Okay,
I think we're short one here.
oh, a short one?
This applicant is in our package, is that correct?
Well, here, I can provide another.
Here's one more.
Yeah, get those out.
I'll take it back.
So, we'll start with going by some history here. If you look at the photograph, this particular lot is 2.13 acres and is at the very end of San Roy Road. The buildable area, according to DEP, because again, the entire lot sits within the coastal protection zone, and we could, I'll go ahead and pass out an exhibit in case there's a question. Melissa, can you give me exhibit 4 and 5? The lot has been a lot of record for many, many, many years. I'll give you and admit into evidence the warranty deed in 1984. And again, as it was transferred to my client in 2013. So it's a pre-planning code lot of record. Because it is a lot of record, even though it's in the coastal protection zone, under section 4.02.02A5 of the planning code concerning coastal protection, it provides that if the regulations regarding coastal protection render a property owner unable to build a single-family dwelling unit on an existing lot of record as of the date of plan adoption, November 7th, 1996, that lies wholly within the zone, then the owner shall be allowed to construct a single-family residential dwelling unit, providing that owner complies with all permit requirements of the FDEP and limits the extent of disturbance to the minimum area necessary to accommodate the dwelling unit and access driveway. So even though it's in a coastal protection zone, we're entitled to build a lot. In fact, most of the houses on San Roy Lane are within the coastal protection zone today. In terms of this county right-of-way, the house next door that was built in 2004, here, this will be Exhibit C, Exhibit D, pass out a set of those.
Which one did you want to mark as Exhibit C?
The 1984 deed, and then the 2013 deed would be Exhibit D. Starting in 2000, at least in 2004, the then planning director interpreted the planning code as to setbacks when you had a right-of-way on a lot to allow for if that you would measure the setback from the property line, and if the setback was, you would look at the greater of the setback or the right-of-way. But you could have your front building site against the right-of-way if it was more than 20 feet. The house next door was permitted that way, and you can see it on your photograph. It borders the setback. In 2012, the then owner of the property, which preceded my client, applied to the county and to DEP for a building permit to develop on this property. DEP, because of the unique nature of the property, because you not only have the Gulf of Mexico to the south, you have the outfall of Eastern Lake to the west. DEP, out of this 2.13 acres, will only allow a building site on this property in, I've been referring to it as the northeast corner, but it's actually the northeast corner that abuts the 33-foot portion of the right-of-way that's on this lot. You can see it on this photograph. It's the pink triangle. That is the only area of this 2.13 acres that DEP will allow to be built on. Because of that, the unique feature of this land is that that particular portion of this lot, it happens to be the highest area on the lot, and there is a 5-foot elevation rise from basically where the easement is, the edge of the easement. It goes up like a hill 5 feet. So the only way to have parking for this house is to build a ramp. And the only way you can have room to get the ramp, and Mr. O'Connell will come up here shortly, and he's the engineer, I'll have him testify, is to configure it in the way we're doing it, where you are abutted to the easement. But before we get there, I want to go to, and Melissa, if you could give me exhibits 9, 10, and 11. In 2012, before my client bought the property, the then owner applied for a DEP permit. And the then county planning department, under Wayne Dice, as a requirement with DEP, you had to provide a letter regarding whether or not you complied with setback requirements. And the county wrote a letter to DEP saying yes. They interpreted the county code, which reads exactly the same today as it did then on this particular provision. That yes, because the top 33 feet of this property, and we're talking about a front setback, is a right-of-way, and that's more than 20 feet from the property line, we would make the front setback the right-of-way, and the 33 feet of the right-of-way is the setback, not the 33 feet and then adding something onto it. And if that, Melissa, do you have those documents for me? If we could mark, what are we on, D? D?
Yeah.
Okay, this is E. This is F. Let me just get some more copies of that.
This is F.
Yeah, you and I did.
Mr. Dykes, what do we have here? We have,
The letter with the Lawton County Planning and Development Services header is Exhibit E.
E,
Yes, sir. And then the other document, which appears to be emails, is Exhibit F.
And here's some more copies.
there's
I'm
L,
sorry, I was going to do a binder, but then as I put them in, it's
there's E.
one of the times.
This is it?
This is E, that's L.
Here's some more of that.
We need 2 more E's and L's.
2 more?
I think we're giving you the extra here now.
2 more.
Okay.
More E's.
2 more.
Okay, Melissa, you didn't give me, I
L.
needed 10. 11. Okay.
We're short.
I'm sorry, are you missing one more?
I think we got it here.
We have it.
You have it. All right, so in 2012, the county took the position that this is where the setback is. Then, after my client bought the property, they sought to renew the DEP permit to build in 2015. This is attached to the back of E. It's a composite exhibit. And there was yet another letter from the county planning department, basically citing the prior letter and approving that it had met the setback requirements. In 2017, we then sought, because when the structural engineer, Mr. O'Connell, who you're going to hear from, started trying to figure out how you're going to deal with this 5-foot elevation, because you got to get the cars up there. It's not like you're driving next door off the road. You're now driving up 5 feet. A requirement was, he determined that a requirement to build was we got to modify the house. So they had to redesign the house to be able to meet the parking requirement. At first, on September 20th, 2017, the planning department sent an email that really didn't address one way or the other the setback. But then on September 25th, 2017, the planning department took the position that they didn't agree with the prior planning department letters on this property, and that we would, so if they would honor if we didn't change the plans the DEP had approved, which now were no longer structurally buildable because, you know, it was originally designed apparently by someone who wasn't local. And when the structural engineer went out there and saw that basically you're looking at the side of a 5-foot-high sand dune when you get to the edge of the easement, you had to do some kind of modification to deal with the parking. So we cannot build the original plans approved by DEP back in 2015. And when I say the original plans, this is the footprint approved by DEP. It's not the actual set of house plans. You know, the way it works is DEP would approve a footprint, and then we would actually take the house plans and go to the county for approval of the plans, which has not occurred, which is why I emphasized in the very beginning, this is not an appeal of a building permit. This is the process of now we're back to county, we need a letter that says the front setback meets the requirements for a footprint from DEP so we can build a ramp so we can get the cars up to where the parking is so that they're not in the right of way. And we're changing that footprint, so we need another letter from you, and now they won't get the letter. They told us to come do a variance, which is how we all arrived here. I'm sorry it's a little long-winded, but I figured you needed to know the history.
You referenced September 25th email.
Yes, sir.
Are we supposed to have a copy of that email?
Melissa?
You didn't ask if you had it here.
Mr. Johnson, you earlier asked me about if I was going to let Melissa speak. You know, she's better at handling documents than me. I probably should have let her speak, but...
It depends on what is it depends.
All right, so this will be the next letter.
We can share them. I just like to see it, but we can share it.
That'll be, Mr. Chairman, that's Exhibit G.
Exhibit G.
Yes.
Gary, do you also have a copy of the original DEP permitted footprint?
Do we have a copy of that?
I'm sorry, the what?
The original DEP permitted footprint.
Yeah, is it the next one? I only have.
I planned when we put Mr. O'Connell up, but I'll go ahead and give you that so you can go ahead and have all the documents before all the testimony begins. I'm kind of a visual guy, so I believe in having things to look at. Here's some more of G.
G.
Yeah, I'm going to go ahead and mark them.
Next one here.
Okay, so I guess this will be H.
Is this what Mr. Chick was referring to?
Yeah, this is a depiction of the DEP approved footprint going back to 2012.
Exhibit H.
H, I think.
Yes, it is.
So I'll be giving you, as Melissa's pulling them out for me right now, but the next exhibits, which would be I and J, is the Planning Department staff report on our application for variance. And basically their conclusion is that absent otherwise determined by evidence provided, the proposed variance meets the Walton County Land Development Code, Section 8.02.02 Standards and Procedures. We've also, I'll be providing you as Exhibit J in just a second, a letter from the South Walton Fire District where they agree with the proposed variance with certain conditions that my client is certainly willing to do. And these are conditions that obviously he can't, the road is not paved in front of the neighbor's property, the house immediately to the east. So he doesn't have the ability to put a road in there. But to the extent that there is a requirement, to the extent on his property, that the fire department would like a road, which they would, he's going to put it in, and he's going to build it to the dimensions that they want, and he's going to build it out of material that and engineered to be able to handle a fire truck. One of the unique things, in addition to the environmental problems with this property, is that to the extent we have this right-of-way, and as you can see from the picture I gave you, Exhibit A, basically the right-of-way runs into the outfall of Eastern Lake. So for all intents and purposes, it dead ends at our property. Currently, other than to access the building site, the only people, unless you pave the road further, that would be able to drive on this would be government vehicles, because once you get past this building site, you're on the beach, and Walton County does allow driving permits for Grayton Beach, and I think Inlet Beach. It doesn't allow them at Eastern Lake, so there would be no private vehicles over here driving beyond where the house site would be, because it would be the beach. But certainly we want the county or the state or whoever needs to get on the beach to be able to get on the beach. So that right-of-way would be preserved. We're not seeking to have parking in the right-of-way. We're not seeking to block the right-of-way. We're not seeking to reduce the right-of-way in any way. All we're seeking is a variance for the front setback that would be consistent with what the county said it would be back in 2015 and 2012, and in the case of the neighbor in 2004. And I'd also point out that while there is a change in the triangular building footprint shape, because of the need for this ramp and the shift, the parking actually west, because I believe, and Mr. O'Connell will explain in more detail when he gets up here, but the little portion of the triangle that's been added to the west, that's the parking, and I think it actually is not abutting exactly the easement anyway. But there would be sort of a ramp system, and you go up and turn into the parking.
Are you, do you represent this drawing?
Do I do what?
Are you referencing this point? Is that the point?
Okay, what I think, Mr. Chairman, and Mr. O'Connell will give you more detail, but if you take H and A,
Right.
put them side by side, it'll show you the difference. Basically, the DEP building footprint, I drew on mine a little line, but basically it's kind of a little, the western edge of the little triangle is the change for the DEP permit. In terms of the actual front setbacks, we're not trying to change that at all. We're saying what the county did in 2012 and again in 2015, if they now say we have to get a variance on, we're asking for a variance. Again, this is only about the front setback. All these other things, you know, if you grant this front setback, we then have to go back to DEP, get DEP, you know, work with DEP on what we can build, because this is a very limited buildable lot. And then when we get a DEP permit, then we'd have to go to the county building department. And then I suppose, as I read all the public's comment about various things, about, you know, height or parking or other items, that would be the time, I suppose, if someone objected, that they would then file an appeal to the issuance of the building permit. We're not there. In fact, we don't, while we have a conceptual drawing of a house, we don't even have that, because we've got to establish our setback, go back to DEP, get DEP to approve a different footprint that provides for us to get up to the parking, which Mr. O'Connell is going to explain much better than me in a minute. Then do a building plan, then go to the county. So we're not anywhere near a permitted house. This is only about a variance on the setback to be able to go to DEP. That's it. And again, on comments regarding, for example, I saw a comment that was complaining about the square footage of the base footprint of the house, that on the conceptual drawings it was approximately 3,700 square feet. And there was a comment about, well, this isn't consistent with the houses on San Roy Beach Road, which I don't know is even appropriate for where we are here, but I'd like to comment on, that's a conceptual drawing, and the house next door, according to the property appraiser's webpage, has a footprint for the first floor of 5,497 square feet, which is 48% larger than what we're talking about. So I don't think it's inconsistent, but whether it's consistent or not, that would be a discussion to have if there was an appeal of the building permit. Because we don't have a permitted set of plans that we're up here talking to you about. We're talking about exclusively how the front setback is going to be required of us for purposes of discussing with DEP whether or not we can change where the parking is, because engineering-wise it won't work on the house that has been approved by DEP. That's it. That's all we're here on tonight. I worry you're looking at me, Mr. Johnson, like I'm confusing people.
No, to me, it's real simple. I think all the board members, is everyone clear why we're here tonight? If you would believe that we understand, let's move along and hear from your other witness, and then we hear from the crowd and get their concerns, and you will have a chance to address. So you have a question for Mr. Shipman?
I do. If you haven't designed the house yet for building, why would you not make it accommodate the existing setback and avoid all this?
Because it doesn't appear that if, well, first of all, it's kind of unclear to us exactly how you do it, because first the county said against, to the easement, then the county said, no, it's 20 feet from the easement, which absolutely would make this a non-buildable lot. Then there was some discussion about, well, maybe it would be 7 feet from the edge of the easement. I think that was raised in one of the things that you received, which may or may not make it an unbuildable lot. Because I got to emphasize, the area that DEP will allow to be built on is extremely small for this lot. So before we go through a lot of machinations of trying to engineer something, we did a conceptual drawing, and that's all it is, that our engineer, who's going to explain, because he's much better at this than me in a second, why that was necessary. But now we have to go back to DEP, and we have to have a letter from the county that in 2012 they were willing to give us, in 2015 they were willing to give us, Now we're saying to do the same thing that we represented to DEP in 12 and 15, we got to have you grant a variance. So here we are.
Another real quick question. This letter from South Walton Fire District, don't have a problem meeting the contingencies he spelled out to make?
To the extent they're on our property, obviously we can't pave somebody else's property.
Yeah.
But to the extent it's on our property, he's agreed to do it.
Thank you.
Let's hear from your architect.
Engineer. Mr. O'Connell, you're up.
Good evening. My name is Neil O'Connell with O'Connell & Associates Consulting Engineers. I was engaged by Mr. Russell in early 2017 to review his civil and structural engineering plans for the purpose of getting a building permit. What I was provided at the time was a copy of the DEP permit, which not only included the permitting for the footprint of the house that's been in question, but also for a dune restoration plan associated with that particular parcel. You've already been provided with Exhibit H, which has this pretty colorful illustration on it. I'm going to provide you with 2 more exhibits here that help illustrate what's happening. So these will be Exhibit K and Exhibit L. Okay, so to go along with Exhibit H, which is this one here, I know that you'll have a whole bunch of exhibits in your hand at this point, but to go along with Exhibit H, which is this one, what we're illustrating here on this side of the page, overall site plan. This is what we're working with, what DEP has allowed our client to work with, Mr. Russell. Here's a blown-up version of that, scaled-up version of that, which shows the permitted footprint. Those black boxes are there to represent vehicle parking. Exhibit, is this Exhibit M? K. Okay. Exhibit K, again, is another illustration of that. It's a kind of a blown-up version of the footprint of the house. Black boxes representing vehicle parking. The vehicle parking there was placed underneath this house as part of the DEP permit by another coastal engineer that's not affiliated with us, in accordance with the requirements of the Walton County LDCs. A certain number of bedrooms requires a certain number of parking. The parking was placed on the plan. Plan was placed on the site. Got their DEP permit, got the letter of compliance from the county, and they were away to go. So then it was passed to us to try and actually get the cars up into the parking spot. One thing that's critically important here is an understanding of the difference in the grade elevations between where the road is and where the DEP permitted finished floor elevation is. Now, what the finished floor elevation is, in this particular instance, used interchangeably with what's termed as the lowest structural member. Okay, so the parking is going to be on a structural slab. The lowest structural member, which is established by the DEP, is at elevation 15.5, but when you get up to the finished floor, it's 16.5. So we've got to get from that elevation 16.5, which is required by DEP, down to the existing grade, which is approximately 11. So there's a fairly significant difference in elevations between where the road ends on the neighboring property and where we have to get to for parking purposes on the permitted site plan. The total distance that we have in order to get that 5 feet in elevation is only 7.5 feet. Okay? So what we know based on that is the gradient of the road there does not conform to any industry standard whatsoever as far as accessibility with regards to vehicular driveways. And so therefore, the slope has to be lowered in order to be able to get the vehicles up that 5.5 foot grade change to get to the parking area. When you lower the slope, you push the parking to the west. So conceivably, once we got involved with actually doing the site plan to make the site plan that was permitted work from DEP, it was our recommendation that the parking be moved to the west. And that was really it. It was only a recommendation based on functionality, based on geometry of the site. So as a result of that, the owner redesigned their site plan to include parking to the west. The parking area to the west, which is illustrated on another site plan, I don't know if you guys have been provided with it yet. Have they been provided with a copy of this? Yes. You have that. This is it. Shows the parking to the west. It was moved out from underneath the house, moved to the west. Yeah, we don't have that.
I've seen it.
It's in there.
We got it. Okay.
Well, I have one copy here, so I'll go ahead and submit that. So does everybody understand the intent here? So the DEP coastal engineer who designed the site plan in order to get the DEP permit was focused on a couple of things. They were focused on the requirements of DEP to get the lowest structural member above a specific elevation and confine it to the upper northeast corner of the site. Now, that particular effort
Go ahead.
That particular effort did not consider off-site grades, and that's what we were brought in to do. When you consider off-site grades, the parking doesn't work, the parking needs to be moved to the west. Accordingly, the overall footprint changes.
Neil, are you allowed to alter the topography of the dune in the right-of-way?
Yes.
So is it the slope from the existing 11 up to
16 and a half, which is,
16 at the property line, that's the issue?
yes.
So you can't manipulate that?
Well, you can manipulate it, but because the easement on the neighboring is on the neighboring property. In order to be able to manipulate it, we would have to either fill off-site on a neighboring property, or we would have to manipulate it to be lower on our site. And in order to manipulate it lower on our site to get the slope down, it doesn't match up with the finished floor elevation of the house. We can't lower the elevation of the house because of DEP requirements. So the slope gets, in order to get the slope goes lower than the finished floor elevation of the house, and therefore the parking that's designed over here and permitted by DEP becomes unusable.
But you said the parking deck was at 16 and a half,
Right.
which is what the grade is at the property line. So you're gonna have to bring in sand around the perimeter of the house to meet your CPZ requirements?
Well,
Permitting, adding additional sand on the site to expand the dune, correct?
correct, yes. Some of the top of the dune is going to be clipped,
Right.
but it's going to be relocated seaward of the proposed footprint.
So if you flatten that dune out across there, the parking could theoretically happen anywhere across the north boundary of the buildable footprint.
In theory, however, you're not allowed to park out there because it's in the right-of-way, so there's no parking
As long
along
as
the
you're
right-of-way.
parking under the house
Correct,
at 16 feet.
correct.
If you flatten the dune at 16 feet, you can get.
Which is what we're proposing to do, but having to shove it farther to the west, because currently, in order to get from the elevation of the existing road up to that 16 feet, the grade is like over 27%.
So you're talking about having to flatten the right-of-way across from the 11-foot contour to the property line and then ramp up to 16?
What we're planning on doing is flattening the area within, lowering the slope within the right of way. So lowering it from 27% to somewhere no greater than 12% to get up to the 16.
So what would that contour be, 13 feet? That'd be about 13 feet?
Well, we're still going up to 16, so we still got to get up to 16.
So the rest of the transition has to happen on this lot?
Correct.
You're saying percent, you mean
Great.
grade, degrees.
Go ahead.
Okay.
And Mr. Chairman, just so we got the record clear, this was the document you were talking about that was in
Yeah, that's correct.
Okay. We're going to go ahead, I'm going to just go ahead and pull this out and mark this as,
M?
yes, Exhibit M. I mean, you can keep it in your book, but for the record, I just want to make sure. That way, if he references it, we know what you're referencing.
Yeah. So to summarize, the parking that was permitted by DEP, you can't get the car from the neighboring lot or from the lot line up to the parking because of the gradient change. So we had to lower the slope, move the parking to the west, and as part of that, when the parking was moved to the west and the new parking garage was moved to the west, they crossed over the boundary of the DEP permitted western limits of construction. Therefore, we would have to go back to DEP and request a new permit. We can't do that at this point because Walton County has refused to provide a consistency letter as far as it relates to the setback.
So in a VE 13, your lowest horizontal structural member has to be 14?
Yes, whatever was shown in the DEP permit.
So you're having to go back to the DEP anyways with the new building footprint to get
Correct.
permitted. So why couldn't the garage slab be at 14 instead of 16?
The way it was originally designed was such that the structural slab was, the finished floor elevation of the structural slab was 1 foot above the minimum required lowest structural member elevation.
But it says on your survey that that's VE 13.
Well, we have an established lowest structural member elevation as part of our permit at 15.4.
Well, you're talking about the way it's designed, but I understand it's just a conceptual design right now, is that correct?
That's correct, yeah. Well, it's a conceptual design, as in there's no plans that are prepared to actually be submitted to the building department. However, it's beyond conceptual in the sense that it's already been permitted by DEP.
In your opening remarks, you said something about dune restoration. What's going to be involved in that effort?
There's a detailed explanation as to what's going on there as far as the dune restoration plan that's been permitted by DEP. And it has to do with manipulation of the existing dune in such a manner that no sand is exported from the site.
But you can bring more sand to the site, correct?
Could do, yes. The intention is to do so.
Go ahead. Go ahead.
Okay.
You done?
Yes, sir.
We do appreciate it. I'm sure we may have you back before this is over with. At this time, we will hear from the county. Mr. Shipman, you have anything to add?
I'd just like to add in for completeness, Mr. O'Connell's brief summary of his report of what he told you. This would be exhibit N. Let me see if I can get you copies of the handout. Thank you.
Yes, sir. Thank you.
Just briefly, Mr. Chairman.
Yes, ma'am.
Sydney Noyes on behalf of county staff. I just wanted to reiterate, I think it was already brought up, but if the board does consider granting this variance, we would ask that you would add the conditions that have been requested by the South Walton Fire District. And I did want to reiterate what Mr. Shipman has already said. A lot of the, I guess, concerns that have been brought to us by members of the public have to do with possible inconsistency with the comprehensive plan. I want to make it clear that if this variance is granted tonight, it would not be a variance to any of the comprehensive plan requirements. So whatever is ultimately approved, it wouldn't violate any comprehensive plan requirements. So if you have any questions for us, please let me know.
Not at this time, but this is something that's been before us many times, and it seems like it's pretty similar to the one that was approved last time, last meeting that we had. Mr. Carpenter, you have anything to add? You want to explain the county's position?
Yes, sir. The reason we're here tonight is because the county refused to renew a consistency letter, or two previous letters that I believe were issued in error. The second one was a replacement, or an extension essentially of the first one without further review. I believe the first one was issued in error because it would allow the building to be sited within the public right-of-way. And the building immediately to the east was permitted in that condition. And if you look at the pictures that were provided by the applicant, you can see a number of cars parked in the public right-of-way. And that we don't do anymore.
The thing you're trying to do is make sure that you clear it up so that doesn't happen.
Yes, sir.
And you advise them to come to get the variance so they can continue with developing a piece of property they have right to develop that is within the comprehensive plan of land development code.
Yes, sir. That is the due process that's available to them, and that's why we're here
And the
tonight.
DEP and all the other permittings that they will have to go through.
Yes, sir. The rear setback, in a circumstance where it's a beachfront lot, we allow the DEP to establish that.
Right.
But the code clearly requires that the front setback be measured from the extent of the easement, and that's our position.
And that's why we're here.
And that's why we're here, because they're asking for a reduction in the front setback.
And if he does not do that, there's a possibility his lot is not buildable, and therefore it would be further seaward, which is not a good thing either. Is that correct?
I can't quite go there, given the size of this particular house that's being proposed.
I understand. Thank
Yes,
you.
sir.
At this time, we will give each person in the audience the opportunity to come up to voice your opinion. If you have legal counsel representing you, we welcome them to come up at this time. Is there anyone here in the audience like to come up? Sure. State your name for the record.
Thank you. My name is Dan O'Rourke. I'm an attorney with Matthews and Jones here representing Patricia Stevens, who is the principal of Patco Energy Limited, which is the owner of 187 San Roy Road, which is immediately adjacent to the lot 13 that we're discussing this evening.
You here representing the neighbor to the east.
Yes.
You want to spell your name for?
Yes, I will. It's capital O apostrophe capital R O-U-R-K-E. I guess the master for me. Your indulgence, I'd like to go over a few things, and then I have a couple of witnesses I'd like to present, if that's okay.
We just don't want to be here all night. We got about
Oh, I
four
understand.
more, so we like to speed this along.
Well, I understand that.
Mr. Dykes?
Yeah, just one second. Mr. O'Rourke, you were handed memorandum
Yes.
as well as some photographs and some other documents. Did you want to consider anything to add?
Yes, there are series of exhibits. One is the memo that was previously provided, but I don't think it made it into your packages, which has memo dated May 24, 2018. And then the next is a photograph. Hold up, just a moment.
What are we going to call these, Mr. Dykes?
We start on numbers.
Challenge. Challenger number one?
I object to a lot of the attachments here. For example, we got a family photograph from April of 1975 by Easton Lake. How is that possibly relevant to what we're here before, which is a variance
on the front.
I uphold your objection. We're not going to allow that. Go ahead. Anything else?
Well, it's actually this whole collection of photographs. They're all dated 1975.
With respect,
And then there's some from '04 and '05 about hurricanes on the beach, where there was flooding on the beach. I assume he wants to argue something about the outfall, none of which is relevant to what we're here tonight.
well, I don't think Mr. Shipman is actually being candid about what is in fact relevant. And, I mean, notwithstanding the large amount of testifying he did earlier without being under oath, as a matter of logistics, I'm simply presenting these exhibits. I will, if necessary, call one of my witnesses who is willing to or able to authenticate and lay a foundation for them. But the fact of the matter is, several of the criteria for granting a variance call into question whether or not there's any unnecessary hardship, whether or not there's a detriment to the public, etc., all of which are brought into question by the proposed 12,000 square foot building that they're talking about constructing.
Can I see his exhibits? Mr. Shipman, you want to give me a little bit of leeway here and give you the opportunity to cross-examine his witness when they come up?
What I would request, based on the tenure of these exhibits, he's going to have to lay some kind of predicate as to how there's a relevance of a picture of a sunset in February of 1975 in the Gulf of Mexico, a picture of apparently a family standing next to Eastern Lake in April of 1975, a picture of what I guess is the outlet from April of 1975, a picture that's labeled Eastern Lake Inlet, September 1975 after Hurricane Eloise, a picture of what looks like a house on a bluff after Hurricane Ivan in 2004, a picture of the beach after Hurricane Dennis in 2005, an aerial photograph after Hurricane Dennis, a picture of a couple standing on the beach after Hurricane Dennis. None of this has to do with the right-of-way and what you would do with a variance on where the front setback is measured. I assume he's going to try to make some kind of argument that would go to DEP as to where the outfall is or how the outfall affects this property, none of which is a decision that y'all get to make tonight.
Mr. Chairman.
Your decision is about variance.
And to speak to the rules of evidence, obviously this is quasi-judicial, and I'll just point you to the Land Development Code, and it states, as it relates to rules of evidence, formal rules of evidence shall not apply. All evidence of a type commonly relied upon by a reasonable, prudent man in the conduct of their affairs shall be admissible, whether or not such evidence would be admissible in a court of law. However, irrelevant, immaterial, or unduly repetitious evidence shall be excluded upon motion of the opposing party or on the board's own initiative. Then it goes on to speak about hearsay evidence. That would be letters and whatnot. So I believe Mr. Shipman has made an objection on the record. It would be up to the board on whether or not it wants to consider that evidence and what weight it wants to give to that evidence. You don't have to lay the foundation necessarily like Mr. Shipman does. Formal rules of evidence, you're not judges who are particularly educated in the rules of evidence. So
the evidence that we want to hear tonight is what is pertinent to the easement that exists along with the setbacks. Now, we don't want to sit here all night and listen to testimony, and I agree with Mr. Shipman about issues that's happened, 20, 30 years ago.
Well,
first of all,
and I appreciate that. The history of this property.
First of all, the county says that he's able to build on that. That's what the county said by the comprehensive plan. This man is allowed to build on that lot. Now, they're asking us for a variance, and we want to keep the focus on that issue of the variance. And we appreciate you in understanding that, and if you want to address that, then please go ahead. But your pictures and et cetera, we're not going to allow that.
All right, then, let me make sure I understand this. By not allowing the pictures, you're not willing to consider evidence of the topography and nature of this property as to. And
According to the DEP and according to the comprehensive plan in the county, that he can put a structure on this property. It has been designed by DEP, and DEP is the one that's the expert on the outfall and the water flow down on the beach. And they are allowing a structure. And we're going to hear tonight about a variance on that easement.
Well, with all due respect, I don't think we've actually seen evidence that DEP is allowing this structure. It seems to be they're trying to say the predicate to them even considering what their willingness to build the structure is that they get this variance. But the fact of the matter is, the variance will be facilitated, if this variance is granted, it will be facilitating environmental damage that is going to be irremediable.
Mr. Carpenter, is it not the testimony of the county that that is a buildable lot and that there is understanding that the DEP will allow permitting for one buildable lot structure?
Mm-hmm.
Yes, sir, we've determined this is a lot of record, and under our comprehensive plan policy, I believe 1.57, they're entitled to build one single-family dwelling,
And
providing they
DEP,
can meet the other requirements of the Land Development Code and the comprehensive plan.
and DEP is in agreement that they will be permitted.
They have previously permitted a house on this lot, yes, sir. I don't know if, I can't predict if this house will be permitted by DEP, but they have previously issued a permit for a house on this lot.
We are going to the assumption that it is a buildable lot, that DEP will be the one to permit it. Now, if you want to take and address the issue as far as a buildable lot and that either for the variance or against the variance, then we'll hear it.
If I may ask,
Mr. Chairman,
Let's let him go ahead.
if I may ask staff, is staff aware of the ownership of this parcel in conjunction with the 187 address up until?
Yes.
Okay.
Yes.
The fact that they were treated as a single lot for a considerable period of time.
yeah, it's been a separate
But it
lot
was-
since at least 1984, we submitted the
But
documents.
it was acquired jointly. Both lots were acquired at the same time by your client, and then he sold off half or less than half.
Here's the permit. I'll be happy to put that in.
No, you're good.
Quick question. Yeah, I got a quick one. I was going to ask staff, that DEP approval was based on the setbacks that are there now, correct?
No, it was based on the zero setback. The county at one time agreed that you could build that.
Yes, it
I
was.
believe
Based on
that
the consistency letter previously issued by Walton County that allowed the front setback to be measured from the lot line and not the greater extent of the 33-foot easement. So they essentially were measuring the front setback from the northern limit of the lot that's encumbered by a 33-foot public easement.
that would allow structure to be built in the easement as the neighbor to the east is building the easement. Is that the interpretation?
That would have been what that permit would allow based on my understanding.
And that was a DEP permit based on that?
Based on a consistency letter issued by the county that I don't believe was accurate.
No, go ahead.
The structure to the east is built to the 33-foot easement line, correct?
Correct.
It's not encroaching into the easement, it's on the easement line.
And the DEP permit for this allowed a different structure that we couldn't get the parking for to be built up to the right-of-way line, not into the easement.
And with respect, number 4 of the criteria that this board is required to consider in determining whether or not to grant a variance states that it must be talking about proof of unnecessary hardship, but it also says evidence of a variance granted under similar circumstances shall not be considered. And I would suggest to you that the situation immediately to the east is not actually something relevant to consider in determining whether or not this variance is necessary.
So you sent out a memorandum to the members of the board that stated that you objected to them building to the same line that your client's house sits on.
But
For
first of
public
all,
safety reasons, which the fire department has now said are no longer an
well, the
issue.
fire department has said with certain caveats that they can still get in there, but I mean, that it remains to be seen whether or not those conditions would actually be met. Second of all, my clients didn't build the house that they bought. They bought an existing structure that was in fact owned by this applicant when he sold it to them for something close to $6.5 million.
Were they aware that there was a DEP permit in place for the lot next door when they purchased the property?
I don't know. I can
don't
ask my
think it's
client,
relevant.
but it
Would they
doesn't.
be the most to gain from a house not being built on this property?
Well, I think everybody that has a concern for the Eastern Lake outfall and the storm surge protection and the dunes that are present has a legitimate concern about this being built, which is, by the way, why these photographs I think are relevant, because they show the history of the dunes and the protection from storm surge and the fact that Eastern Lake, the sweep of that outfall, covers most of this lot.
Including your client's house in the image that you showed us.
I believe it's immediately to the west, but subsequent to that, the dune that they're talking about building directly on top of
Is the only thing
is
left.
the only remaining dune, therefore obviously the primary dune, which they admit is in fact the primary dune. They're talking about building on top of it and admit that the landward toe of that is pretty much right up against that easement.
Neil testified that they were going to be bringing in additional sand, which the DEP actually encourages everybody building on the Gulf of Mexico to do, because it builds the dune up and continues to armor the coastline. And so they would actually be in favor of adding sand on that lot, which would prevent the outfall from moving further east in a storm event.
Well, in point of fact, one of the exhibits that we presented is the DEP file showing that in 2005 and then again in 2015, the owners of this property, in fact, pretty much leveled the dunes and were required to restore them. And now they're asking for permission to basically level them again, which does not make any sense. The point, and that's the point, that the variance, even if the variance itself is not problematic, the fact that it would permit further development in an area that is not otherwise developable is problematic. And that is the concern. My clients have also expressed concern that, yes, that area is the only access to the beach for emergency personnel in that area. It is unquestionable that there's going to be parking in that area. I mean, and the other question is whether or not the minimum variance is even been approached in this instance.
What would your outcome be? What's your desirable outcome?
My desirable outcome is that if this gentleman is going to develop this lot, he do it without variance from the Comprehensive Plan and Land Development Code, and that frankly, something less than a 12,000 square foot residence, which is at least 30% larger than anything else in that area. And when you get down to it, when you talk about what's the minimum variance required, it doesn't even look like he's trying to come up with that. He's wanting to build. I mean, he bought these two lots through a foreclosure, $900,100. He sold $187.
I think that,
years later,
I don't see where that's relevant. He has a lot of record, it's buildable, and we need to stick to the issue. Now, voice your opinion as far as the variance and what's you for the variance, not the variance. We don't need a history about where he bought it from. It's irrelevant how the gentleman attained it. According to the county, he's on the buildable lot with the DEP and with the permitted. Now present your argument against the variance and let's move on.
That is part of the argument, sir. That is part of the argument.
Well, it's immaterial because it is a buildable lot.
I'm not arguing that it's not necessarily a buildable
then.
lot, but that's something that's going to obviously be considered, further by DEP and others. But I do think that this board, in determining whether or not to grant a variance, should look at the entirety of the situation and determine whether or not, one of the factors that is, in point of fact, it says because someone could make a greater profit from a variance is not a factor to consider. I would argue that the inverse of that is in fact true. If someone has already made a significant profit, that is something to take into consideration in determining whether or not they should be given further exemption or variance from the Land Development Code.
Okay, you stated that, Mr. Shipman, just go ahead.
I'm going to have to object whether or not he makes a profit.
I agree, it's immaterial. We've given the gentleman a chance to finalize his argument. Go ahead.
At this point, I would like to call my first witness.
Call your witness.
Bill Horn.
State your name for the record, please.
My name is Bill Horn, H-O-R-N.
Mr. Horn, can you give the board a brief explanation of your background?
I'm a retired marine biologist with the FWC for 22 years. Prior to that, I worked for the FDEP in Hazardous Waste Enforcement Section out of Jacksonville and worked for the state for 35 years.
And do you also have an interest in property around Eastern Lake?
Our family bought property on Eastern Lake in 1959. So I've seen quite a few changes to this lake, and not for the better for most part.
I'm going to show you, this is the set of photographs that Mr. Shiven has objected to, and I would ask you to at least identify them for the board.
These 1975 photographs are pictures taken from the deck in front of our house towards the channel, showing the primary dune that sits on this lot that we're talking about. It shows it prior to Hurricane Eloise, and then it shows after Hurricane Eloise where the dune was cut in half and destroyed basically from the storm surge that came in. And it shows that where that house is proposed to be built is in the floodplain. Part of it is in the floodplain and will be subject to flood from a future storm, in my opinion.
I have to object to this testimony again. It's not relevant to this issue of variance, how variance is applied on the road right-of-way, nor is what happened in 1975.
I agree with Mr. Shipman. Let's move along.
I'm going to move these into evidence one more time. I would move these into evidence. Mr. Price?
I would object.
I was saying to the objection.
The board will need to decide, do you want to accept these into evidence or not?
No.
He sustained the objection.
Right, it's the board's decision, it's not just the chairman's decision.
Oh.
But the board has to decide whether or not it wants to consider it as a whole.
Look, we're here to take and deal with the issue of the variance. We understand that it's an overflow of the lake. We understand that there is issues when the hurricane comes. We understand that there's a flood. We understand when there's a hurricane, your neighbor or your client previously is going to be affected by it. We understand that. But it's also the fact that the lot is a lot of record. We cannot keep the gentleman from building on it. With a DEP permit, they're allowing him a portion in his exhibit that shows a pink area that he can build on. And we're going to take and deal with the issue of the variance that is concerning the DEP permittable use. Now, we understand that that lake is going to be covered with water when there's a hurricane, tropical storm. We understand that. And I don't think you need testimony for, for this board to see the picture.
I'm going to ask this identify this, please.
This is a map that I put together showing the current placement of the Eastern Lake Channel, showing it well within 100 feet in this case, within 45 feet, the footprint of this proposed house within 45 feet of the existing water to the Eastern Lake Channel.
We'll move this into evidence.
Yeah, but Jeff, this isn't an issue on the front setback. Whether or not, first of all, it's a platted lot. So, if what they're angling toward is that we don't get to build on the lot because we're a lake, fine, the government can do a taking action and pay my plat for an eminent domain. But as far as what the buildable site is, on what by law is a buildable lot, that's up to DEP to determine. We're here simply on whether or not the front setback is going to be calculated from the property line, which includes the road right-of-way, or it's some other calculation. That's it. We're not asking for some variance on a side setback. That's up to DEP.
It's interesting that council wants to take advantage of the land development code provisions when it helps him, and of course wants you to consider them irrelevant when they don't help him. The fact of the matter is, even if this is determined to be a buildable lot, that's also not the issue that's before this board tonight. All right? That's not what's to be determined. What's to be determined is whether or not you're going to grant a variance and what the effect of that variance might be. And the factors that are set forth in the land development code call on this board to consider the hardship as well as the detriment to the public and to the public welfare in granting the variance. As a result, if this board makes a decision, it is making it easier to build on this lot by granting an exception to the land development code. Beyond that, that might be permitted if it's determined to be a buildable lot by some other arm or branch of the county government. All right? So that's the question for you, and as a result, the history of this lot, the uses of it, and the effect of this variance are relevant, and this is the point of introducing this photograph.
Would you agree that it's a buildable lot?
I'm actually not able to offer an opinion on that.
Would you agree that if DEP says it's a buildable lot, that it's a buildable lot? Would you agree with that?
Again, I don't know.
If DEP issues a permit and they said you can build a structure on it, then you have to agree it's a buildable lot.
Well, there's more than just DEP's requirements that have to be met.
If DEP and the building department said, if DEP and the building department says, planning department says you can build a structure on it, then it's a buildable lot. Okay? Let's go with it's a buildable lot. Let's give your consideration the outflow of Eastern Lake.
Mm-hmm.
If you take the outflow of Eastern Lake, would not the house be better to have it forward to the north than to the south by 20 feet?
I don't know, and I'm not able to testify to the benefit there. But the fact of the matter is, whether or not it's a buildable lot, again, as I said, is not what's before this board tonight. And that's a question that's going to be decided elsewhere. This board needs to consider, though, whether or not a variance should be granted and what the hardship might be as a result of that variance or that necessitates that variance. Part of the argument that we're trying to make is that this applicant purchased this property well aware of these restrictions, knowing what was going on, and had use of it before selling off part of it for a considerable profit.
I don't think that's relevant to the issue before us. But
what's relevant is the fact that he wants to build a 12,000 square foot structure on this property, and there is no evidence that he has made any attempt to reduce that to a size that is more appropriate and better fitted to the unique environmental characteristics of this property. That is what I'm trying to get this board to consider by asking that these photographs and other evidence be taken into consideration. That's all I'm doing. I would just ask the board to take the evidence into consideration. What weight you give it is obviously up to you.
we'll take them into consideration, but one understanding, let's move along with this, because I think it's pretty clear, we'll let them be entered. What they gonna be called, Mr. Dykes?
We'll mark them as public exhibit 1 composite, because you have.
You want to just do it as a composite, all of them?
Right, but.
There are actually 5 of them, but.
Right, and we'll note Mr. Shipman has objected to them, but again, the board can
Go
decide
ahead.
what weight to give
Thank
them.
you. All right.
I just wanted to add one thing before we move on. Mr. Shipman indicated that this lot had an environmental problem. That this is a wonderful environment. This is a beauty. This lot is a gem. It doesn't have a problem. It needs protection. The problem will be with development.
All right. In light of the fact that we got the photographs into evidence and the rest of this into evidence, then I'm just going to ask my client, Ms. Stevens, to come up. And I have just a couple of questions for her. And
Thank you.
We should be done.
Well, wait a second, I'll get to cross-examine him. I have a couple of questions.
Yes, you get that opportunity.
Sir, is your real goal here, you like this piece of property and you'd like it to stay the way it is?
Yes.
You don't want them to build a house?
It would detriment, it would hurt the lake. It would
Okay.
harm the lake and would harm the environment around the lake.
So the focus of your testimony is not about whether or not you're concerned about this right-of-way on the top. It's that you don't want a house there.
The right-of-way will allow for the construction, possible construction of this house, if the variance is granted. If the variance is not granted, it's not a buildable lot.
Thank you.
Ms. Stevens?
I think it actually is a buildable lot without.
Let's just not start anymore.
Sorry, ma'am, state your name and spell your last name, please.
Patricia Love Stevens, Stepheens.
Ms. Stevens, you're the, through an entity, are the owner of the property immediately adjacent to the property in question tonight? Is that
Yes.
correct? Okay. It was earlier seemingly testified by Mr. Shipman that that property that you own has something over 5,000 square feet in its footprint. Is that accurate?
No,
Okay. Can you tell us roughly what the ground floor footprint of that property
I was told it was 1,700.
Okay.
I think 1,750.
Okay. Would it surprise you to learn that it's probably closer to about 2,075
It
square
would
feet?
surprise me.
Okay. All right. Nothing further then.
I got a cross-examination.
Yes,
Ma'am, have you ever seen the property appraiser's report for your house?
The property appraiser's report, no.
Okay, let me show you a copy. Do you have any explanation as to why the property appraiser says your house is total 8354 and the base area, meaning the bottom floor, is 5497?
Objection.
No, I've never seen that.
Thank you.
I would,
I'm sorry, sir, please don't speak unless you're up at the mic.
thank you, Patricia. My last witness. I
sure.
promise.
My name is Cole Barr,
Spell your last name.
B-L-A-I-R.
Okay. Base area based upon what we were just talking about, can you explain that to this board?
Yeah, the base area just means what the heated and cooled area is.
Okay.
Yeah.
And so that would not necessarily be the ground floor, it's the total,
The total, yes.
including all three or multiple stories?
Correct.
Thank you. Nothing further.
Mr. Shipman?
Cole?
What's your occupation?
I'm a real estate broker.
You ever been a builder?
No.
Did you build this house?
No.
Did you list it?
No.
Have you been inside it?
Bunch of times.
Okay, have you measured it?
No.
Okay.
As a realtor, do you look at property appraiser reports?
I do.
How many bedrooms are in this house?
8.
8? How many parking spaces are at this house?
Garage parking spaces?
Just, I don't know, how many parking
I
spaces?
believe there are 3 inside.
Okay. And how many bathrooms are in this house?
I believe 9.
That's all I have.
We would ask the board to consider the contents of the memo and the additional exhibits in making this determination.
Thank you. Are there anyone else in the audience like to come up?
I have some handouts for the board. Jimmy Coon, K-U-H-N.
What we're gonna call them, Mr. Dykes?
Publix Exhibit, Publix Exhibit 2. And it's a composite.
Can I see them before we go and move them into evidence?
They are? Thanks, sir.
Mr. Chairman will give Mr. Shipman an opportunity to review them, see if he has any objections.
Are those the same images that were in the package that from the email objections?
I'm not sure. I don't know that I saw all the email objections. These were. Karen believes they were included, but.
I realize we have liberal evidentiary standards on something like this. But when we get to this exhibit, first of all, it's just simply his writing. The first page is him telling us what his name is and where he and his wife live. He can testify to that. It's not in the exhibit. We get further to the historical photographs. He was wanting to show you the outfall of Eastern Lake in 1941. There is no way.
I would argue that is relevant.
Hang on a minute.
That is relevant to the issue of a variance from a setback on a county right-of-way on the top of the property. In fact, in 1941, I don't believe that right-of-way even existed. So all of these photos, again, this gets back to, I guess, the same argument that we heard out of Mr. Blair, Mr. Horn, who at the end of the day, his last words were, if the variance is not granted, it's not a buildable lot. It's not what we're here on. We're not here to determine whether it's a buildable lot. The law decides that. It's about whether or not we get a variance on the right-of-way. And this has nothing to do with that, so I object to it.
May I speak? I would argue that it does have everything to do with it. I would argue that it does have everything to do with it because the location of the outfall has a lot to do with where this house should probably be built, I would expect, and whether the county should allow this variance to be approved. So I would argue that a picture in 1941 of where the outfall was, a picture in 2013 of where the outfall is or was, shows, what I'm trying to show is the variation through time of this outfall. It's not just the way it is right now on this document. This thing is active. It moves from year to year and within the year. And I think that's important for the board to consider where this outfall is and the fact of how that outfall will affect this right-of-way and the type of house that will be built on this lot.
I think it's getting to a little bit of we've heard this before from the previous.
But I don't, excuse me, I'm sorry.
I agree with Mr. Shipman that it is not relevant to the issue that is before us tonight. We understand about the outfall. But we're going to allow it and let's move on.
Thank you, sir.
But now, there will not be any more. I don't want, I'm not going to allow any more pictures of the outflow or how it changes. I mean, I think it's been pretty well done. So go ahead.
My name is Jimmy Coon, K-U-H-N. My wife and I live near Eastern Lake, and we're opposed to the granting of this zero setback variance and for the construction of this house. In fact, we're opposed to a house being constructed in this area, just so Mr. Shipman knows my position. The historic aerial photographs show this variation in the outfall. In the following pages, I'll show Mr. Russell's proposed house in relation to the outfall from 1941 to 2016. These photographs were geo-referenced using Esri ArcMap software, so the location of that is as good as I could get it in relation to the outfall on these photographs. And the photographs were geo-referenced also in relation to known points on the ground. I'm on page 4. The result of the geo-referencing allows us to get a glimpse of how Eastern Lake outfall has historically varied its location in relation to Mr. Russell's plans. The lines on the map on page 4 shows this variation from 1941 to 2013. Each line on this map represents the outfall in a particular year. The outfall location in 1969, which you'll see is a wide pink line, is of particular interest because it intersects the location of Mr. Russell's proposed house. Page 5 shows the photographs that I used to come up with these lines from 1941, and it also has the photograph from the 1969 image that I used to draw that pink line. There are also images on page 6 from 1971 to 2003, and on page 7 there's images in 2013 and 2016. The point is to show this variation. This is not a static item. I assume the county has to hear these variance requests, but I can't imagine that the body would consider to allow someone to build a house in a rare coastal dune lake. There's one house built on the edge of the outfall and it looks to be in a precarious situation. That's a picture on page 8. The next big storm could take it out. With the debris that could enter the lake and the resulting insurance claims that would arise, why would the county want to continue to have this problem? The hardship setback variance just doesn't seem valid to me. Can we all request a 20-foot setback on the front of our property to the right-of-way? If that's the case, I would imagine approving this sort of thing seems to open the door for everyone to claim a hardship to build to the edge of the road right-of-way in the front of their homes. Emergency beach access on the San Roy Street. The county has been stated owns a 33-foot right-of-way, holds a 33-foot right-of-way on the north side of Mr. Russell's property. The right-of-way can be used as an emergency access or an access for people in the neighborhood to get to the beach. The right-of-way is sometimes blocked by vehicles at the house to the west end of San Roy, and you can see this evidence in the photo that was supplied in Mr. Russell's packet of cars parked at the west end blocking that right-of-way. Allowing zero setback would just add to this dangerous problem. I thank you for allowing me to speak and allowing me to admit my...
Would you believe that this is a buildable lot?
I can't say. I'm not an expert in that area. The DEP has approved him to be able to build on this lot with a certain setback that was issued that Mr. Carpenter has said that he feels that setback variance was given in error if there was in fact a setback variance. And so now the reason we're here is to decide, can he have this setback, which will determine the size of the house that Mr. Russell can build. So the DEP has said it's buildable. I'm not arguing that point.
Okay.
I'm arguing the point that how big a house do we need to have here? Is it safe to have this house built right up to the right-of-way of where the emergency vehicles and people access the beach? We've seen what happens at the end of San Roy when people park their cars. You can't get through that area if you have an emergency vehicle. And that's one of the big concerns we have.
One of the things with this lot is that road is a dead-end road and it's not drivable.
That's right.
So it's not like it's a 30A or a lot of traffic on it.
Yes, sir.
But it's still a concern of yours that people drive there?
No, sir. It's concern for emergency vehicles getting through there. That's the only access, except for another mile down the beach. There's an access for people who can get onto the beach in Walton Dunes. It's for emergency vehicles and for the county vehicles to get on.
Have you seen what the South Walton Fire Department has recommended?
I have not seen no one has said here today what the stipulations are. It's just that they would approve it if there were certain conditions met.
If South Walton Fire Department says they will approve, or, no problem with it, then that takes care of the emergency vehicle issue in your eyes?
It still doesn't take care of the parking problem that we're going to have. And when, I'm not a fire expert, I'm not an emergency expert. I just know what I've seen walking down that road. I've seen cars parked there time and time again that would block vehicles an emergency vehicle from needing to get onto the beach at that location.
We appreciate your comment. Thank
Thank
you
you,
very
sir.
much. Anyone else? I think the gentleman in the back stood up first. State your name for the record.
My name is Clifford White. My wife and I just recently built a home on North Lake Drive, 22 North Lake Drive. I know before you talk about relevancy and so forth, but what I'm about to say is relevant. You've got everybody hopping mad out here based upon the comments that you made. My previous occupation was a special agent for the Office of Inspector General, U.S. Department of Agriculture. I've had a little experience appearing before judges, but not before a panel like this. I realize you've got a job to do, and I respect that. But you're here to represent the people that are in this room. And I know you're not going to like this comment, but a permanent resident, longtime resident, business person that lives on my street told me when I went and talked to him about this, how do you feel about this? Do we have an argument? He said, Cliff, you're wasting your time. You're wasting your time to go there. Money talks. Money talks.
All right.
Mr. Shipman, let's give him the benefit of the doubt and let's talk to him a little bit. Let's indulge it.
All right, well, if we're going to have somebody accusing something improper,
Well,
they can come in and say it, not him.
I'm not accused Mr. Shipman or his client of anything. I'm just simply relating to you what a permanent resident has related to me. And I'm beginning to think he's 100% correct based upon your comments here tonight. But with that said, let's get to the point here.
Appreciate that.
Yes. Whether it's a buildable lot or not, I don't know. I could care less about that aspect of it. What I know is when we got ready to build this house in 2016, and it was completed in 2017, there was these rules in place, and rightfully so, to protect this national treasure that we have, Eastern Lake. As you know, and I'm preaching to the choir now, I understand that. This coastal dune lake is one of the most special lakes in the United States, in the world. And so the county has wisely adopted these rules to protect this lake. One of them being is, and this has been adopted since we bought the lot. Anyway, 100-foot setback. Nobody else on our street, all those lots on the lake, except ours, are built out. But anyway, 100-foot setback is what we had, okay? I'm okay with that. The next thing was a 25% you cannot disturb more than 25% of this property. What did that do? That restricted us to a very small footprint for our house. Now, apparently, just from where I can gather, The applicant here doesn't want to be stuck with a real small footprint. He wants to build this mega house on this property. Well, it sounds like to me, from what testimony I've heard here tonight, he's bought a lot that's not suitable for this mega house that he wants to build. Okay? Now, we complied with the rules. I asked an official here in this building, a government official, is there any chance we could get a variance to this 25% rule? And he said no. He said no. We live by the rules. But now then, effectively, the applicant here is wanting to say, oh, we don't want to go by those rules. Make something special for us. Do something special for us so we can build this mega home here. So that's basically what my comments are. I previously submitted by email on March the 22nd, 2018, my comments, mostly not what I've just talked about here, and I've updated that. And so I wanted to leave these prepared written statements with you. Whoever I need to give that to, I'll be glad to.
Item 3. Public.
Public 3. Just hand them to the lady.
Item to Karen. We do appreciate it.
You're welcome.
Thank you, sir. We're going to do one or two more. Come on.
Fred Tricker, TRICKER, representing South Walton Community Council in support of the Eastern Lake neighborhood. And we want to object to this variance, and I'm going to be brief, I promise.
Thank you, sir.
We heard about the DEP permit that, as we also heard, is no longer valid. It's a moot point. It doesn't exist anymore because the plans changed. On the drawings on the site plan that were submitted as part of the application, there's a DEP boundary line that's shown. Approved boundary line no longer applies. There's a proposed boundary line on the drawing to accommodate the parking garages on the western edge of the property that it hasn't even gone by DEP. There's making assumptions about what is allowable. Well, if you look at that western boundary, it actually sticks out, puts the building closer to the dune lake. And this is in the coastal dune lake protection zone, and my understanding is that you can't build within 100 feet of the lake. And that corner of the structure, unless I'm mistaken, is within 50 feet of the lake.
I believe that with a 66-foot right-of-way, if you look at their drawing, that's a 66-foot right-of-way. There probably appear to be another 50 foot before you get to the outflow.
Not the outflow, the lake. And I was looking at the site plan. I was eyeballing it from the site plan.
If you look at this drawing that shows the 66-foot right-of-way, it is quite a distance from the lake.
Okay, well, I could be mistaken, something that needs to be checked. My point is, we don't know exactly what the boundaries are that's going to be allowable by DEP. We don't know for sure about the coastal dune lake limitation. We don't really know what could be built there. I agree it's a buildable lot. We don't know what could be built because the applicant didn't provide us with any information to show what could be built if he adhered to the setbacks.
Well, let's give them the opportunity to answer.
Okay.
Stay right there.
Okay.
Mr. O'Connor? Mr. Shipman, you want to address that?
I'm sorry, I was.
What was the methodology you used?
The question is, what would be buildable on this property if we adhere to all the requirements, the DEP requirements, which we don't know for sure, I understand that, coastal dune lake protection zone requirements, and the 20-foot setback. What could you build?
Are you within 100 feet of the eastern lake?
We're within 100 feet of Eastern Lake.
I can't hear you, can you stand up?
We're within 100 feet of Eastern Lake, yes.
You are.
No, I'm sorry, we're outside of 100 feet of Eastern Lake.
What was the methodology for calculating the setback from the lake?
Survey. From the surveyor.
When you say, and are you saying, referring to the lake being this area here?
That's
Or
correct.
this outflow area?
One second, Mr. Chick, just so we have a clear record, you're referring to Exhibit H, the applicant's exhibit.
A.
It's not labeled.
A.
Or I'm sorry, B, that's B.
B.
The application was A. I just want to make sure we have a clear record, so that's applicant's exhibit B that you're.
So is this area, does this area have an established setback
That's
requirement?
the outfall. There's a 50-foot setback from the
It's
outfall.
50 feet? And we're not encroaching into that 50-foot setback?
We're not. Not with
All changes.
the, not with the existing plan and not with the proposed future plan.
So we have that answered.
Okay, the question is, what size structure could be built there if we adhere to all the required setbacks and allowable boundaries? What's the size? I mean, is it a house? Is it 5,000 square feet? Is it 2,000 square feet? I mean, how can you show a hardship if you don't have a comparison between the 12,000 or 10,000 foot structure that's being proposed and what could be built? Where's the hardship? You don't know what it is. You haven't quantified it. And if it's a 5,000 square foot structure, instead of a 10,000 square foot structure, I suggest that's a profit motive. Profit motive is not a justifiable reason to approve a variance, according to the standards.
Do you think that the house would be better away from, closer to the beach?
Yes.
You think?
Yes.
And why?
Well, I think the 20-foot setback should be respected. And what that means, you can only build a smaller building, which I assume, and that's highly desirable. I'm against, in general, letting people build really big homes where they're not entitled to build really big homes.
Okay.
So just one other thing regarding the uniqueness of the situation, and somebody already testified to it, and I can tell you, I'm trying to get a building permit for a home that's in the coastal dune lake protection zone, and I've been working at it for a year. It's cost me a lot of money. I can't build the size home I want to build, and that's okay. I'm living with that. And so the unique circumstance they're talking about is not unique. It happens all the time. Thank you very much. Can I put this into the record, please?
Plaintiff number 4?
Public number 4.
Public number 4.
Stand it. Okay.
The gentleman in the back raised his hand first. I do understand that everyone is concerned about this issue, but we also have 4 or 5 other variances we need to get to. So we need to move this along, if you would, help us please.
I'll do my best.
Thank you, sir.
Gordon Davis, 253 South Gulf Drive, DAVIS. I'm an Eastern Lake resident. I am against the variance for a couple reasons. Mr. Chick, during your examination dialogue with Mr. Shipman relative to the height, it was 16 feet was the magic number?
Correct.
Was that correct? It was 16 feet?
16.6.
Yeah, so do you know historically what the storm surge was for Dennis and Ivan here?
Probably 24 feet.
Yeah, okay. So that alone should tell you that we're facing potentially, we don't want to talk about the past, right? But historically speaking, there we run the risk for some damage there to the lake. Secondly, in 2004 in Dennis, the storm surge brought debris from the beach all on the shoreline of Eastern Lake, and the county was kind enough to contract and come take all this debris off the shoreline and clean up Eastern Lake. They weren't obligated to, what they did. Thirdly, before Dennis and Ivan, the previous homeowner, you're talking about bringing sand in. That should concern you. Because the previous owner brought sand in, and the county caught him and issued a stop work order. Consequently, when the storms hit, over 15 dump trucks of sand were thrown in the mouth of Eastern Lake. The lake has not been the same since. Not at all. And I could go on. 2 more points and I'll leave because I'm quick.
Okay.
Point number 1, the easement. South Walton Fire Department, you know, how they come into play with planning, I have no idea, but I'll ask each one who's here. Have you ever witnessed a drowning on the beach? Anyone? Have you seen our first responders and having struggle because they're fighting with tourists and cars? I've witnessed that. Okay? That alone should tell you there's a problem. Their hardship is just that. It's hardship. How someone can have a hardship because of the piece of property he bought, fortunately for him, opportunistic. And last but not least, without getting into names, in 2015, when he was the previous owner was developing that piece of property, okay, he liked to bend the rules. He was doing construction at night. He tried to build and bury a propane tank in the back of his yard, which was against the county. Okay, I understand, but you know, being a good steward of land, we reward good behavior. You guys have a set of laws and rules here. This variance, this setback, is extremely critical for our first responders. If nothing else, you ought to consider that.
We will. Thank you very much. Ma'am, come up. What? And there again, I'm going to take in caution, we will close this in just a few minutes because we're beginning to hear that it's repeating itself and we don't need to hear the repetition. So if you would, let's get to something different. Go ahead.
Brenda Reese, R-E-E-S. I'm a resident of Eastern Lake. Family's been there since 1958. For differences, I would want to first say that you need to deny this variance for hardship and detriment to the public. I'll keep this one, but here's a 1992 aerial of Eastern Lake, and you can see how the storm paths came in. There's also 30A up here, and I stayed for Hurricane Ivan and watched that come in and took pictures. And when the storm surge comes in, the storm surge goes out. And it comes in other places than the outfall, but this is a primary entrance and exit for storm surge to come in and to also go out. So right now, Walton County has about 60,000 residents. In 10 years, according to Bobby Beasley, our supervisor for elections, we'll have 120,000. Half of those now are in South Walton. I would imagine half of those 120,000 will be living here, many of them. So we need to protect the public that's going to be building properly, probably following the rules around the lake. There's apartments here now. There are many, many more people coming in, living around this lake. 30A bridge there until it can be built into a span bridge. It is a real block to that storm surge, so it'll come in, hit that. Some of it disperses up into the Point Washington State Forest, but the rest of it comes back down and it goes out that way. So keeping that clear is very important. I would say that the historical record of a coastal dune lake is very important. People were ignorant for a long time about what these coastal dune lakes were and how dynamic they were and how water surged in and water surged out. And so you cannot deny the history of the movement of that outfall. And the outfall goes through that lot. I ran out of ink, but I'll consider.
Ma'am, we have pictures from 1940 to 2006.
But you don't have this one that shows some sand, because I stayed for the hurricanes, and the point about this is loose sand. You cannot replace the primary dune, and sometimes palmettos live between 400 and 600 years, and that's those historical root system. This loose sand that was brought up on the beach, that does not replace this primary dune, which is of importance to protecting all those upland homeowners and visitors and travelers along the road. So it is important, this whole, I'm going to bring in some loose sand. It does not replace this primary dune, and particularly on the right-of-way. This is a 2001 official stamped plat of that area that shows a 33-foot wide Sandroy Road, as well as a 33-foot wide access on the north side. So you can see where lot 12 is the government lot, which abuts is the lot 13 below it. So it's important that this variance is denied for public safety. And also, one last thing on this picture here, a lot of the other houses were used as a reason that they were larger. Well, you'll notice all the other houses, except for that last one, next to this lot, are way back from the road and closer to the beach. Okay?
Thank you, ma'am. Let's close. The gentleman with the ties, the attorney. And if you, now listen.
I'm not an attorney, I'm not going to waste your time. I'm Stephen Tatum, by the way, last name's Tatum, and don't hold that against the next variance that may be coming up, who is a Tatum, not any kin.
Well, let's get on, let's move on now.
Okay,
Wasting your time.
Everybody's gotten off track, and we're talking about all kinds of different things. We're not looking at what the Land Development Code says is required in order to issue a variance. I know that's what you started off wanting to talk about, so let's talk about what's required. There are 7 requirements. Every single one of them has to be answered in the negative in order for you guys to grant a variance. Every single one of those 7. There's a lot of them I could go into, and they're maybe the environmental, maybe not. Number 5, there's absolutely no way you guys can say with a straight face that the granting of a variance is necessary for the reasonable use of the land, and that the variance as granted by the board is the minimum variance that will accomplish that purpose. Now, I'm not going to argue with you about whether or not the lot is buildable. It may not, it may be, may not be. But the fact is, the Land Development Code says if all of the different protection zones make it so that a house can't be built, one single-family residence can be constructed. It does not say any single-family residence that they want to build can be built. You cannot answer number 5 in the negative with a straight face, so there's no reason you should be granting this variance.
Okay.
Thank you.
Thank you. We're going to give this here 5 minutes. We got 3 more, and we're going to close it. Ma'am?
My name's Christy Yanchis. I work for the U.S. Fish and Wildlife Service.
Sorry, spell your name.
Yanchis, Y-A-N-C-H-I-S. Christy, K-R-I-S-T-I. This property likely does need a permit from us. It has not had a permit before, unlike the previous one on Sandroy further down. We have been working with the applicant on and off for the past couple years. I've been out to the site. We don't have an exact site plan. In light of all this, we probably need to sit down with DEP and the county, everyone in one room, to come up with something that's going to work for everyone, to suffice everyone's requirements and stuff. I can't issue a permit without an exact site plan, and if, that's not where we are right now, because it doesn't meet your rules, doesn't meet DEP's rules. I'm not an advocate for or against the project. I just wanted you to know that there's other permits that they need, other requirements that they have to meet, and stuff like that. So I don't know if you have any other ecological questions. A lot of environmental and ecological concerns have come up. Mine's primarily for endangered species, the beach mice, shorebirds, and sea turtles, and the habitat that would then be all around the house and the dune lakes as well to connect it. So.
Thank you.
Did I?
Christy,
you guys have any?
Christy, are you saying that it's a buildable lot?
So that's not my, I mean, it's platted, that's what I look at. It comes into us, it's a platted lot. I can't
if they
say
put
it's
a-
not, because that would be a taking. I can't take someone's lot. I can make them, what we look for is minimization. I want it as small a footprint as possible on the landscape. I would like it to be further, as far away from the Gulf, as far away from the coastal dune lake. This lot puts us in a position where that's a little difficult. So I think that's what a lot of the argument's about. I think we just really, DEP really is going to have to be a player with us and with the planning department to figure this out. I don't know how the variance process goes in that. It sounds like it has to come first. I'm not even sure if that's, I don't know. I don't know if that's the right way it should go first or not, because we don't have an exact footprint to really evaluate.
Thank you,
But
ma'am.
I think
We're gonna
we
move
can.
on. I got, no, two more. You want to dispose, sir?
I want to ask her one quick question.
Go ahead, Ms. Shipman.
Fish and Wildlife, did I understand you to say Fish and Wildlife would prefer this house to be as far north as permissible?
Yes, as far north as permissible.
Thank you. Two more people, and we're closing it. The gentleman over here.
Thomas Field, F-I-E-L-D. I live in property directly across the outfall from this. I was speaking to the gentleman here, and I heard them say something a while ago about the DEP permit that was made a while back and approved. And it sounded like, I told him, it sounded like it was up to this line. He said yes, but that was in error, and that has expired. So that DEP approval that approved it at that point in time, he said was incorrect, and in fact, then it is also expired. So it should have no bearing on what you do here, that somebody else made a previous mistake, and that's what he said, that you're not bound by some previous mistake.
We understand that.
All right. And the people that are here are people that live there. You keep talking about the pictures and things like that. That's where they live. That's why it is that way. But I agree, your position here is just to decide about the variance.
Right.
And you've asked several people, do you agree it's a buildable lot? And I guess that's the point of thing. We're standing here for variance to make it a more buildable lot, or something bigger buildable, or something other than what it might be. The property owner bought this property, had full information about what it was, looked at it, bought it, also sold other property off of it. So he is not a neophyte in this building, so he knew what he was building. So in order to apply for this variance, he's asking for something different than he bought. I see no reason why this board should consider necessity to give him a variance of something that he had full knowledge of in an area that's quite...
We have heard that testimony before. We've heard the testimony you've given before.
I'm sorry, I didn't hear it the same way, but, you know, am I superfluous?
We have 4 other variances that we got to get to. I feel like that it's getting repetitious. I like to close it as soon as we can.
I apologize for being repetitious. I thought you asked for input.
One more. Yes.
My name's Larry Pentel, P-E-N-T-E-L. I've lived on Eastern Lake for a while also. Something that has not been mentioned is the property adjacent to this property is owned by the county. It is used as a county park. The only way to access that side of the park is through this road. They will be building directly up to a public access to the beach and the Gulf. As all of you know, access is getting more and more difficult to the public property for residents and visitors to use. Anything built right up to this will impede access for the public to this Gulf front property and lakefront property owned by the county. Most of it is not vehicular, most of it is people walking. However, it was mentioned about emergency access, so forth. The code enforcement officers use that road quite a bit to get their trucks on and off the beach. In addition, the county maintenance department uses this access to open and close the access of the lake outfall at the 33-foot easement on the other side. They unload their equipment on this access. Anything built right up to it will impede their use of it. As to whether it's a buildable lot, I imagine it is. It's a dune. It's high. It's whether somebody wants it there or not doesn't matter. But they have land to build on. They should be able to build on their lot without impeding everyone's access to county property. There was also several items brought up about DEP permits and so forth. I do have a little bit of information that was not brought up. The previous owner of this property got a DEP permit for dune restoration in the mid-2000s in order to build on this lot. They did not restore dune. They brought in roughly 20 truckloads of sand and built a dam to keep it from eroding into the access and this dune that they're talking about. My wife and I sued the DEP with our own money, and the DEP said, oh yes, you're right, that permit was issued in error. Unfortunately, as someone else mentioned, a storm came in while this was in process and washed all that sand into the lake that has created, I don't want to say more buildable land, but has created higher elevation than what was there prior to this. So part of this variance is in sand that wasn't even meant to be there, if the variance is granted. The original initial dune is in the part where there is no variance. And if they want to build a house there, great.
Thank you, sir. Mr. Shipman, you want to do your closure?
Yes, there's just one thing with your indulgence. Since everybody's had all these questions about
the DEP actually ever permit, I'd like to go ahead and admit the 2012 DEP permitted.
Sure. It's going to be applicant. We're getting close to Z yet?
We're getting closer. We're at Exhibit O, I believe is where we're at. There's applicants at the top of the
Ms.
Sorry, just real briefly while Mr. Shipman gives out that, could we introduce the staff report into evidence, please?
Absolutely.
Thank you.
I thought we done and did.
No, I'm sorry.
Well, I did it, but I didn't have the exhibits attached, so I love to
So this would be staff's staff report and all the attached exhibits. Thank you.
Go ahead, Mr. Shipman.
Okay. And one other comment I wanted to make, and if need be, I can have Mr. O'Connell testify to this, since this issue was brought up about the 25% coverage rule of the coastal dune lake. This lot is 2.13 acres. The coverage with the concept drawings is less than 5% of the lot. So that is not an issue here. I want to emphasize again, as we're asking for this variance, this is simply to, once again, this is to begin the process. As we heard from Fish and Wildlife, we don't have anybody from DEP, but we'll have to bring them in here. They want the house as far north as we can make it. This has nothing to do with how big the house is going to be or how small it's going to be. DEP and Fish and Wildlife and probably some other government agencies are going to ultimately dictate all this. But we can't even get there without either getting a letter out of the county or a variance here. In 2012, I guess the county, quote, made a mistake, and then they made the same mistake in 2015, and I guess in 2004 when the house next door got built. We're just asking, allow this so that we can address the parking issue, so that we can get with DEP, so that we can have a house designed, so that we can have parking that's not in the right-of-way, so that it doesn't block anything. We absolutely agree that we cannot use the county right-of-way for parking. With that, if y'all have any questions, I'd be happy to answer it. Otherwise, I think you're ready for us all to be quiet.
Do you have a square footage of the house?
The footprint.
Do you have a footprint? Under the current conceptual, I think the footprint is 3,700 square feet, give or take a few feet.
If you do not get the variance, how is that going to affect that?
If we don't get the variance, and the calculation by the county is that it's 20 feet off the setback, It may very well be an unbuildable lot, and everybody will get their wish, and we'll be in an eminent domain proceeding with the county.
Thank you, sir. Close the public discussion. As long as it don't open up a can of worms, you go ahead, but we could close this.
I'd like to ask the county a question. If we were to grant the variance, the DEP would still be required to issue the permit ultimately, or issue them a
Yes.
permit. If this would give the DEP leeway to move their building further to the north and east, if they were to require that to happen, that they would have that option to say, look, we're going to move our line a little north and east for you. Will you? This variance would allow them to tighten up their little spot that they can build on and push it more north and east, as opposed to leaving it where it is.
I can't comment on whether or not the DEP will issue a permit because that's not within our control. What the county will do, we will write a letter of consistency that is consistent with whatever this board decides. That is their ticket to attach to their permit application to DEP, and then that decision belongs to DEP.
Okay, thank you. Motion to close.
Motion to close.
Motion
Can I ask
second.
Mr. Shipman a question very quickly?
It's got to be quick now.
It's
We got
quick.
to move on. I mean, we beat this horse to death 4 or 5
Would
times.
you be willing to accept the variance to the front setback if it was restricted to the width, so you didn't encroach closer to the lake?
I think the problem, we already had the permit that was the same on the north.
It's that, as Mr. O'Connell explained, we have to go west in order to deal with the elevation issue to get the car on the property to park. That's the whole, it's not about moving it to the north and east, it's about moving it a little bit to the west.
I'm pretty sure Mr. O'Connell could figure out a way to make it work without encroaching closer to the lake, because most of the people that are here are very concerned about that adjacency to the lake. So granting the variance puts the house closer to the lake, and I can see where there's a hardship where a man buys a piece of property with a DEP and a county permit in place, saying you can build one footprint, and I can't imagine
All right, Chick, let's move on.
expanding that footprint towards the lake.
Motion to close it.
Motion to close.
Second.
Second.
All in favor, aye?
Aye.
Motion.
I'll make a motion to deny.
We have a motion to deny, second.
Second.
Discussion.
Well, since I made the motion, listening to Mac's comments, the fact that the DEP permit may have been an error and has expired, the fact that the person bought this property knowing the problems that he had with it, I can't even imagine wanting to build on this lot in the first place. And then designing the house, I think the house can be designed that would fit within the current zoning or setbacks.
I have an issue with the county approving it, giving,
Yeah,
permission,
I do
giving
too.
consent on 2 or 3 different times, and then you have interpretation where that doesn't work, and there's offer to compromise, not compromise, to take care of those issues that was the concern, is a request for a variance. You sat there and I know whatever decision is made, probably not going to be happy with the people that's here. But anytime that you can move a structure closer away from the beach, I think you're better off. I'm concerned with everybody here. I know they don't think I am with the comments that I made, but that piece of property is owned by the individual that has a right to build it. I personally think the gentleman has a right to build the lot. I don't like the idea he has a right to build a lot. The county has to give him a permit. If you don't give him a permit, then he's going to take and sue the county, and there's going to be money paid for it. But if you take and the variance that pushes away from the beach and a little closer inward. Let me explain something to y'all. I clear the ring. We have a discussion, or you can stay, or you can leave. You had your say.
Mr. Chairman,
Yes, sir.
I have a few thoughts, if I may.
Yes, sir.
I see at least 4 things that are influencing this property. The coastal construction control line, which is imposed by the state of Florida. A front setback that is imposed by Walton County. A dune lake setback that is imposed by Walton County. A coastal protection zone that is imposed by Walton County. Each one of these things in themselves, and certainly coupled together, in my opinion, constitute a hardship. You're trying to design a house in a triangle. We all know how hard that can
That's
be.
right.
I don't, this is this is at the end of a dead-end street.
That's right.
And the 66-foot right-of-way will be preserved. You're not supposed to traverse across private property, the county, the public, private individuals from that 66-foot right-of-way to get to the beach. And again, I think a hardship exists by virtue of what the public has imposed through the counties and the state.
I agree.
I think, I agree with most of the people out here that the impact to the lake and everything is a huge concern, but that is not what we're addressing. We're addressing the ability to put it closer to the easement in the front and not towards the lake. And I think anytime you can push it north and east, that's significantly better than building it towards the lake. And if we grant this variance, that it would, the DEP would hopefully issue their permit with him having to push everything north and east more than having it to be closer to the Gulf and the lake itself. I think he has a hardship in the form that he had a letter saying he could do all this, and a permit from the DEP previously, and now he's not allowed to use that. He's got to come back to get a different one. So I think there was a different hardship there. I think to speak to neighborhood conformity, the house next door is up against that easement, so it's going to be similar. The footprint doesn't sound like it's significantly different than any of the footprints around. If 3,700 to 2,000, it is my wish that it be a smaller house and more north and east, and I think this variance would give it that ability to go north and east as opposed to closer to the lake and closer to the Gulf.
Okay.
My concern is that the granting of the variance as it was presented would also create a home footprint that moved farther to the west and closer to the outfall. And the original DEP permit limited the scope of the house to a 68-foot line west of the property line, and that the new design to accommodate parking is moving the garage and parking and all of the 25 feet of additional sand to meet the CPZ requirements closer to the outfall. So I would be in favor of moving the house to the northeast as well, but not with if it allows the house to continue to move towards the west. And I think that the footprint that was in place with the previous DEP permit is very reasonable. So to expand that footprint is unreasonable because there's no hardship for the size of the house. You can get plenty of house on the original DEP permitted footprint. And I agree that the house next door is built to the 33-foot easement, and you've got 66 feet of access to that area, which seems more than adequate. So my only objection would be to extend farther to the west than the original 68 feet of the DEP permit that was in place in 2015.
Bill?
Well, 2.5 hours of passionate discourse, And I love passion. It's one thing I don't like is apathy. And I just want to say to all of you, thanks for coming and voicing your concerns. I don't think that, I'm convinced, I'm just not convinced that a variance is needed for the reasonable use of the land. And I understand Darrell's comments about hardships, but I don't want to confuse hardships with constraints. We all have to live within the constraints. I think the engineers, and we've got good ones, they can make this work within the constraints that we have. So that's why I'm against the variance. I'm just not convinced that the variance is needed for the reasonable use of the land.
We have a motion to deny, we have a second. Phil, how do you vote?
I vote nay for the, I vote for the.
To deny the variance.
To deny it, I vote aye.
Check.
Nay.
Aye. Nay.
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 You got your variance approved?
No.
No? No?
No, the motion fails. Now you have to have a motion and a second to grant it.
Just a minute to clear the room. Motion to approve?
I make a motion to approve the variance.
Second.
As submitted, with no limit to the western.
Let me clarify that. I make a motion to approve the variance as submitted with the stipulations and conditions of the April 3rd, 2018 South Walton Fire District memo.
Second. I need a second.
I'll second for discussion.
We're not going to discuss it, but I'm discuss it.
I'd like to give Mr. Chick the opportunity to make an argument.
We are going to, we had this discussion, we voted, we have a motion to approve it with conditions, we have a second. Mrs. Burgess, how do you vote?
Aye.
Charlie? Motion to approve.
I'll go aye.
Aye.
Nay.
Chick?
I have to vote aye.
Phil?
Nay.
The variance was approved.
Mr. Chairman, can we take a...
Those that send opposition has 30 days from the time the final order to file an appeal with the circuit court. Anyone needs to go to boys' room?
Yep. Yes, please.
We'll take a 5-minute break. Let's hurry up.
Some of them, Sydney will be a little bit delayed, but we can move forward without her.
Well, we got 2 board members that evidently got lost. I tell you.
See if I can find them.
I don't want to eat. I want to get through this. Do what?
Before you came.
No, it makes me sleepy. Where's Phil at? All right, we call this back. Everybody's back. Ms. Matthews?
Chairman, Commissioners, this will not be 2.5 hours, I swear. This is, I represent Leighton and Teresa McCown. They own Lot 10, Block B in the village of White Cliffs. This is a, quote, type 4, Roman numeral 4 house under the CCR, the Declaration of Covenants and Conditions. Mr. Chairman, and I think most of you gentlemen on the board, I was before you in December of 2017 on behalf of Mark and Vivian Furr, another owners of another lot there. Had to go through the same drill on a variance request that y'all approved, and there's the final order that was recorded. Very similar setbacks that were being requested here. The issue is that from 1993 until 2015, the County Building Department issued building permits based on the architectural review design guideline setbacks at the Village of White Cliffs, which are different than the county's. 2015, Mr. Dice writes a memo, and then all of a sudden, everybody that wants to build a house there with their setbacks in compliance with the Village of White Cliffs, but different than the county's, has to come before this board for a variance. I think this is the third or the fourth one, second one I've been involved in. Don't know how much history that you want other than that. I do have a copy of the last order that y'all signed and approved unanimously.
Does all the board members understand what we're dealing here?
Yes, sir.
I mean, do he need to go into detail?
No, sir.
No. And there's no opposition, staff's in support. I got the town architect, or the Village of White Cliffs architect, does have ARC approval. I did, whatever our application that's in the record, our mailing affidavits, the green cards, move that into evidence just for the record, but I'm here to answer any questions.
Sit down. Now, Mr. Matthews, what we're going to do is listen to Mr. Carpenter, and then we'll give you a chance to come back.
Mr. Chairman, Mr. Matthews is absolutely correct. Up until 2015, the county recognized the covenants and restrictions in this development. We were advised, and the director subsequently determined that we didn't have the authority to do that based on the approval of this particular subdivision, and that this was the remedy for that.
Very good.
Well, Matt, do you want to put in?
That we meet all 7 problems.
We'd like to enter our staff report into the record.
So entered. Any opposition? Mr. Matthews, anything you want to add?
No, sir.
Motion to close public discussion.
Motion to close.
Second.
Second.
All in favor, aye?
Aye.
Motion to approve.
Motion to approve.
Second.
Second.
All in favor, aye?
Aye.
Thank you, sir. That's quick. We made up some ground. Who's number 3? 4. Who's number 4?
Can you do the next one?
Mr. Matthews, you want to stick around in
Mr. Chairman, for the benefit of the board, this next item is the exact same circumstance.
Okay. Same subdivision?
Different subdivision.
Different subdivision.
Different subdivision.
State your name for the record.
Josh Tatum, Tatum. And as pointed out, very similar issue just brought before this board. We have a residential home in Bay Bridge Landing that falls within that same category that was explained. We're within the 15-foot setback of the county, but within the 10-foot setback of the covenants and restrictions of the neighborhood.
All right, you're asking for, since we're not as familiar with this subdivisions that we are with White Cliffs, you're asking for a reduction in rear setback from 15 foot to 10 foot.
Yes,
Because you
sir.
thought that it was a 10 foot, and it's obvious that you already started your house according to the pictures. Is that correct?
That is correct, yes, sir.
And
The house is
therefore,
fully
you have
underway.
stopped construction, and if you don't get your theirs, you're going to have to tear the house down. Is that correct?
That is correct.
Any questions? Anyone has any concerns? Any issues? Mr. Carpenter, you want to add a comment? Vivian, you sleeping over there tonight?
Yes, sir. Matt Carter for the Planning Department. This is a similar circumstance to the last one where the covenants allow something that the county doesn't have the authority to continue to allow without the variance.
The difference is this gentleman would spend a tremendous amount of money modifying the house.
Yes, this circumstance is already under construction.
This
Yes,
is
sir.
kind of a hardship.
I believe you can find that,
All
yes.
right. Anyone here in opposition? Anyone here for it? Mr. Tatum, you want to play? You want to say?
Could we enter our staff report into the record, please?
So entered. Anything you want to add?
No, sir.
Thank you, sir. Motion to close the public discussion?
So moved.
Who made the motion?
I make a motion to close public
Who
discussion.
seconded it? All in favor, aye.
Aye.
Motion to approve.
Motion, go ahead.
Motion to approve the variance.
Second.
All in favor, Mr. Burgess? How you
Aye.
vote? Charlie?
Aye.
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 Thank you. Man, we're moving on. Told you we'd get out of here before 9 o'clock. Who's next?
For the convenience of the board, I'm Matt Kirk for the planning department. This is a very similar circumstance, except that what they're asking for is a variance to the setback shown on the plat, where they have an inconsistency between their covenants and what was actually the recorded plat. But it is still very similar.
Okay. State your name for the record.
Thank you for hearing me. This is Paul Geary, T.S. Adams Studio Architects.
Paul Geary.
Geary, G-E-A-R-Y. The subject property is Lot 13, Vermilion Point in watercolor. As you can see, this entire street has been built already. This is the last remaining lot on that particular street and that side of the street. We actually were the architects of Lot 14, right immediately adjacent, and Lot 16 right next to it. We developed plans based on, and I'll call your attention to the watercolor guidelines, which are this form with the salmon colored lot layout. And you'll see that watercolor requires, or is asking for a 5-foot rear setback. The county plat in this particular area is a 10-foot rear setback. And so we developed plans basically for 14 and 16 several years ago with the 5-foot required setback according to watercolor. They went through planning, went through the permit process, got an approval. And as you can see, and all I did here was basically just connect the dots. We know that carriage house is built on the 5-foot rear setback, and this pool is built on the 5-foot rear setback. And so you can see the entire street, just by connecting the dots, has been designed and built to the required 5-foot. Presumably because in this day, when all these houses were built, the county was just going with whatever watercolor was imposing. Our hardship in this case is that as the last lot on this street, watercolor imposes further restriction on this lot as opposed to these other lots, in that they require a side porch requirement here. So in addition to the parking that's obviously required by watercolor, which is pretty restrictive, there's a 5-foot separation between a parking structure and the main house, a front facade zone, which requires an 8-foot deep front porch, and then a side porch of 8-foot by 24-foot on the side, on the cul-de-sac side. So already just imposing that without the 5-foot rear setback, or the 10-foot that now the county's asking for, basically we're, in comparison, in terms of square footage, they're only able to do like a 4,700 square foot house. The houses we've done on 14 and 16 are actually up in the 5,300, and as you can see going down the street. So in other words, what I'm trying to say is our hardship is as you go down the street, the lots are getting more restrictive, and then on top of it all, watercolor's imposing a side porch requirement on this, which is imposing even further restrictions on this lot. Now
You want to stand? You want to stand to put it on? I was trying to see if you was going to give.
I didn't want to mess with that thing, so I asked her to hold it. So in this case, this is the last remaining lot. All this entire street has been allowed to be built to the 5-foot rear setback. All we're asking for is for us to be allowed to do that exact same thing. The only thing that we're planning and back in there is a porch in that area and a pool. And the support of the neighborhood is pretty much unanimous. I've gotten support from both neighbors.
Hang on a minute.
Yep.
County's asking you to have a 10-foot, you want a 5-foot, you asking for a 5-foot setback. Is that correct?
Correct.
Anyone has any questions? Everyone have a clear understanding? Yes. Let us see if anybody's in opposition. Mr. Carpenter, have you said your piece? Yes, sir. Anyone in opposition? You want to add anything real quickly? Motion to close public discussion?
Staff report.
Mr. Chairman, this county will enter its staff report.
So enter. Thank you, Mr. Knight.
Motion
Motion to close public discussion, second.
Second.
All in favor, aye?
Aye.
Motion to approve?
So moved.
Second.
Take your pick, Karen. You can have Mr. Burgess, you can have.
Take Burgess. I think he got me by half a second.
You good, Karen? How do you vote, Mr.?
Aye.
Aye.
Aye?
Aye.
Aye.
Got your variance.
Thank you.
See, that was simple. Who's next?
I actually did the house on 17. It's got a 5-foot setback.
Go ahead, David.
Yes.
I just wanted to pay a compliment to the previous applicant because they put together one of the best packages that I've seen.
This, the one we just heard?
Yes.
Thank you.
Good job.
Hey, Paul.
Hello.
You got 5 minutes.
Okay. I will try my best.
What you here for? State your name for the record.
Bob Smith, SMITH. I have actually written down what I want to say, so I'm just going to read it and then I can elaborate after that. We're requesting to change the side setbacks from 7.5 feet to 5 feet so we can position our home for the best possible use and enjoyment. My wife and I own this little piece of property and want to build our retirement home here. We looked very hard to find the perfect house plan that would, number one, fit on the lot, 2, fit into the neighborhood, uphold the unique character of the area, and provide at least a glimpse of the beautiful Gulf of Mexico. The footprint of the house that we picked fits with the current building setbacks, but as we got deeper into our planning, we found that the deck on the 3rd floor overhangs the side setback by 4 feet. That's when we realized that we would have to adjust something somewhere to make this work. We've tried everything we can think of to be able to build a house without asking for a variance, but have not been able to find a way. We looked at trying to eliminate the deck, but the deck is what makes the house what it is and gives it the charm that we love about it. We looked at reducing the house footprint width to accommodate the deck, but that would make some of the rooms unreasonably small. For example, a bedroom would, from roughly 10 foot, it would decrease down to 6 foot wide. We've looked at countless other house plans, but haven't seen anything that comes close to comparing with this quaint and lovely home. We also have a narrow sliver of paradise down a 13-foot easement on the west side of the property. To obtain even that view, we need the house that we build to be as close to the west edge as possible. When the Florida DOT widened Highway 98 in 2001, they took a significant chunk of our property. If not for that, we could have positioned the house differently, giving us a better vantage point, hence a better view of the Gulf. And so that's why we're requesting the setbacks changed from 7.5 feet to 5 feet. And I'll show you a couple of things here and elaborate on a couple of things to point out what I was talking about. Everybody see this? I need to move it over. They good?
You're good.
All right, so this is our house. My dad bought this piece of property, this whole piece right here in 1981, with in mind that he wanted to give that to his children, which I'm one of. I ended up with this piece, but in between that, the Florida DOT came in and widened Highway 98, which, as you can see, took a significant portion and also makes it difficult since it's an angle. It's very difficult to do what we want. And this is the 13-foot easement that I have that I'm going to be trying to see the Gulf from. And these are houses that are going up right here in front of me, between us and the Gulf, and there's one existing house there. So we're trying our best to configure it so that we can see around these houses as much as possible. And this is a picture of the house our house will be patterned after this one. And you can see this is the covered deck that does the overhang, but without that, I mean, that's just what we love about the house. And You know, we're not asking to have a variance to build a bigger house. I mean, it's a modest house, it's 2,000 square feet. We're just wanting to have a good view of the Gulf, or a view of the Gulf. And this one just shows where I was talking about if we did narrow the house to accommodate the, right now the bedroom is 10 foot and it would be 6 foot if we, you know, shrink this to get the 4 foot covered deck in. That's it.
Basically, you want a 2.5 foot variance on the side so you can see the Gulf of Mexico.
Yes, sir.
Okay, let us see who else is here in opposition. Let's talk to the county first. Vivian?
I think this one boils down to basically what are the unique circumstances and what is the hardship. Should you determine that they have proven hardship in unique circumstances, the county would not have an objection to the reduced setbacks.
You gonna go into politics one day, Vivian?
I might.
Thank you.
Mr. Chairman, may I ask a question of the applicant? Or am I-
May I ask him?
Yes, sir.
Sure.
Okay. Looking both at the photograph in our packet and the previous rendering, only the third floor deck would extend the 2.5 feet into the setback?
Correct. Well, it would extend 4 feet beyond the current setback.
Okay. The ground level and second floor would be still adhere to the setback?
Correct.
Okay.
Yes.
Thank you.
I got a quick question. The highway taking part of that property was only on the end of it. It didn't impact the width of the property at all, correct?
That is correct, but we would have been able to position the house further back on the lot, which would give us a better vantage point. You know, if we were back here, it would help us to see beyond and around these houses.
Without that overhang?
Right. No, yes, without the overhang, yes, sir. And the thing is, you know, the closer we are to here, we're staring in the face of these buildings. So if we were back further, we could see them a little bit better.
You say you asking for a 2.5 foot setback, or you asking for a 4 foot setback?
It's 2.5 each side.
2.5 each side. That would allow us to move this, you know, the house over to the 5 foot, and then the deck would fall on the 5 foot as well.
So you asking for 2.5 feet on each side?
Yes, sir.
But the deck upstairs is built how many feet in?
4 feet.
4 feet into the
existing 7.5 foot.
So will he need a 3.5 foot setback?
And move the house over.
No.
Can you pull the,
More than advertised.
Pardon me?
Need more than what is advertised.
You understand that you only advertised for 2.5 foot, and you're gonna need a 4 foot variance.
Well, I'm asking for 2.5 feet on each side, total of 5 feet.
would you pull the picture back up of the outside of the house?
The picture of that?
Correct. So the balcony that's on the top and the roof overhang of the balcony, the edge of that balcony is how far away from the property line?
4 feet.
So you're asking for a 3.5?
So you need a 3.5 foot.
Well, I didn't know you could go in increments of something other than 5 feet on each side. What I'm asking for is change it from 7.5 on each side to 5.5 on each side, which would let me shift the house over to get, you know, I got to shift over 4 feet. So it would let me shift the house over enough where it would compensate for half of it going this way and the other half of that going
that way, if that makes sense.
So with the 5-foot setback, the balcony will be within the other
Yes.
5-foot setback?
Yes,
And then,
Okay. As long as I had it on both sides,
okay.
yes.
Are we understanding this correctly, Mac?
Based on the plans that were submitted as part of this application and the appearance of this structure, I'm not sure it will fit in even the reduced setbacks that he's asking for.
It will. Yes.
The plan shows a 4-foot deck on the other side of the house.
Oh, I'm sorry. Those, I'm sorry, I should have mentioned that to start with. That was just what we were patterning the house. We're not having a deck on the other side.
We just want to make sure that you understand.
Yes. Oh,
That picture won't fit in
I'm
what you're
very
asking.
sorry about that. Let me
And now,
show it on this.
This says 25 plus this 4-foot balcony.
more than 18 inches.
Yes.
You go 29 feet.
So what
That'll fit.
he was talking about was the original plan showed a deck over here too, but we're not doing that deck. So it's modified to just have, this is the outside, and then where that other deck is would be the other outside.
What you asking for is a 2.5-foot setback on each side.
Yes.
No, he wants 5-foot setbacks.
A reduction.
2.5.
A reduction of, a change from 7.5 feet to 5 feet on each side.
You're asking for a 2.5-foot variance to the 7 on each side.
Yes, sir.
Mac, is this one of the lots that qualifies for the reduced setbacks based as?
No, sir, to qualify for that, the lot has to have been created prior to 1975, and it has to be non-conforming with the 1975 subdivision regulations, which would mean that it has to be less than 10,000 square feet at that time. This lot has been subdivided. It was a lot of record, but it's been subdivided with a family lot split.
Okay, we got a gentleman that'd like to come up and address us, so if you would, state your name for the record.
Ladies and gentlemen, my name is Rich Jaffe. It's J-A-F-F-E. I'm the president of the Historic Inlet Beach Neighborhood Association. And quite frankly, I'm sorry we're all here. I hate to be here in opposition to Bob's request. He and his family have been residents in Inlet Beach, property owners, members of our association for quite a while. He came to our board, I don't know, a month ago, maybe more, and expressed his desires to modify this property and build the house that he'd like to build. The board listened to him. We had our resident architect, Frank Green, in fact, chime in and try and offer some suggestions. The reality of it is, regardless of how we feel about Bob Smith, that we are in opposition to this variance for this very simple reason that there is no hardship here. There is no motivating factor to grant a variance here except for the fact, as Bob said, they want a view of the Gulf or a better view of the Gulf. That is not grounds for a variance. The properties just south of him belonged to his family as well. The buildings going up that will interfere with the view of the Gulf are on property that was owned by his family. The properties going up that are will block the view, your view of the Gulf, are on the properties that your family sold, yes?
Yeah.
Yeah, okay. Those are big houses. There's no argument about it. But the application for the variance here should be based on some kind of hardship. It's not. This is the same kind of issue that we argue in front of you all, in front of the commissioners on a regular basis. When a property owner comes up and says, I want a better view of the Gulf, I want to do something outside the norm, the reaction routinely is, and should be, show us why that's a hardship. It's not. Ergo, we would ask that you deny this variance and that indeed Bob and everybody else try and build within the requirements and restrictions on the properties that we all have. That's it.
He's asking for 2 variances. On one side, he doesn't have a deck. I guess that's because he needs it for the size of the structure. Is that correct?
Yes.
Are you opposed to the variance so he could build the house that he wants to build if we don't grant the variance with the porch that for him to have?
I would ask the exact same question. Show me where the hardship is on building the house on this piece of property, or an appropriate house on this piece of property. Show me where hardship is. I own a house. I am building another house. Just like many of the people in that first issue said. We live within the requirements and restrictions. Those are the regulations that are imposed by the county. You have a variance program designed if there is extraordinary need, if there is a hardship, a true hardship. Show me where it is. When those issues come up to our board and there is indeed a hardship, somebody made a tactical mistake, you want to build a wheelchair ramp, whatever. We don't have problems with those things. We have problems if there is a request to do something outside the norm and there's no hardship.
All right, got you. Mr. Smith?
Well, I would submit that the hardship is that Florida DOT took part of our property, therefore making us need to make arrangements however we can to get the most out of our property, what's left of it, that we can.
What's the size of your lot?
The lot is 40 feet wide, and this side is 130 feet, and this side is 114 feet.
How large is your house?
26 by 52, I think.
26.
Yes, sir.
You got 26.
Oh, 20.
It's gonna be 30 with the
Yeah, it's going to be 20. It's going to be 30 counting the deck. I'm sorry. And
Your
unfortunately,
basic structure of your house without counting the deck, what size is it?
without counting the deck, it's
Yeah.
25 foot 6.
25 foot 6
Yes.
by 50 feet.
Yes.
So you have 1,000 square feet on the bottom.
Yes.
You have 1,000 square feet on the top and the middle. You have 4,000 square foot house.
Well, the bottom is basement.
You have three living quarters?
No,
Is it 4-story or 3-story?
it's a 3-story.
The tower is the third story. Gonna look just like the photo.
No.
You're gonna have
This
another
will have a
floor in
basement
addition to
under
that.
it. So then there's this floor,
What's the
and
tower?
I guess it's called the tower floor, yes.
So it's gonna be 4.
Is this house designed, the one that you're wanting to build? Have you got building plans?
I have them started, I'm not finished. And to speak to what Rich said about their architect, yes, I did go to them and asked them their feelings of this. And he did offer to look and see if he could help in some way to adjust something to where it would fit without asking for the variance. And I tried and hounded to get him back with me to tell me what he found. So obviously he never found their way to help. So that's how that went down. I even called Rich, I don't know, 3 at least times to get Mr. Green to call. And I called Rich and emailed, not Rich, but Frank, emailed him and called him several times and no response.
Let's get back to your house. You got a 25-foot house, that's not counting the deck. If you take, what is the hardship? Okay? If you take 2.5 feet, so that'd be 23 feet wide, correct? Not counting your deck upstairs, because you said that's 4 foot?
Yes, 4 feet.
Well, if you did away with your deck, your house is still what, 25 feet?
Yes, sir.
25 feet would fit within the setbacks, right? So I don't understand exactly where you coming up with 2.5 on each side.
The 4-foot balcony at the top of that tower is the encroachment.
This right
So
here-
he's moving it closer on one
So he wants
side.
to gain that 4 feet,
He wants to move it over and then shift that over so he can see, but the actual size of the house, he don't need a variance. Gotta be 25 feet.
To have that balcony, he would need.
Yeah, but if we cut it off,
What, I'm sorry?
What, I can say, I can offer some advice here, that there's a pretty big buildable footprint there. And so you're trying to shoehorn a house that doesn't fit onto the setbacks of that lot. I think if you were to start with a clean sheet of paper, you could design a 4-story house that had incredible views of the Gulf without using that particular floor plan, which has been built a lot of times. I've seen it around.
Well, we felt like, we're not looking for a bigger house. I mean, we could have a lot more square footage just using the setbacks that we have. Because part of the 26 feet comes to this little part, which is, that's 4 feet itself. So we could build a bigger house if we wanted a bigger house, doing what you're saying. But this is the house that I think fits in with the character of the neighborhood, and it's something that we love. And it's not, it can't be the same without this feature that is what drew us to it in the first place.
I think what Jeff is saying is that he could design you a 4-story, or a house could be designed 4-story that you can see the Gulf without asking for a variance. Is that what you're saying?
That's fair.
Well,
Because, I know that people don't believe it, but we do try to take and listen to opposition, and we do try to understand the community, and we also try to understand yours. But there again, where's the hardship? Like he said, to see the Gulf is not a hardship.
understood.
Mr. Chairman, may I ask a question
Sure.
of the applicant? This may be for the applicant or even for Mr. Carpenter to clarify. I'm looking at the survey in our packet, it's the last page. Your lot's 40.85 feet, and the one immediately adjacent is 40.85 feet. Are those two lots the result of a family lot split?
Yes, sir.
Okay,
Yeah.
so you knew what you were doing when you created these lots, and the widths you were going to have to work with.
That's true.
Okay.
Well, when my dad first bought this in 1981, it was one lot. It was this whole lot.
I understand.
So when we split it, it just turned into water.
You've answered my question. Thank you.
Any other questions?
I would just make the comment, I have trouble issuing these variances when it hasn't been built and you can design something to fit with the existing setbacks.
Well, I don't know. I mean, all I can say to that is this is kind of the house of our dreams, and we want to build our dream house to retire in, which is in the very near future, I hope. So, and as far as building, I do understand what you're saying. I could build a bigger house and a 4-story house, and we could see the Gulf. Well, this house is a 4-story house, so all I've got to work with is this strip right here.
I was under the impression that you were adding a floor to the picture of the house that you were showing us, that there's going to be a ground floor, then 2 stories, and then the tower. So the county considers that a 4-story structure, which would require fire suppression and a general contractor to build it. So it's already an enormous structure that you're proposing to build.
Right.
I think that there's a way to design that tower to give you the great view and have it look like the house of your dreams without requiring the additional setback.
If it could look like this one, then yes, but we've looked and looked and we haven't found a way. And what I'm getting at here is, this is 13 feet, and I need to use as much of that 13 feet as I can, to look down. And if I'm over here, which is the tower, which is, the deck off the tower, which is where I would be spending my time, and the wife would.
Tell me again what size that deck is.
It sits out 4 feet from the property line.
But is that the total deck?
It comes here and here.
What's the dimensions of the deck total?
It's 4'8" and then 4'8". It's an L shape.
Okay.
Mr. Smith, I think we have a general idea of what you're asking for. I think we've heard from one gentleman in the audience. We'd like to see if there's anything else. Anyone else has any comments on this? For, against, county?
We'd like to enter the staff report.
So entered. I'm going to give you one last word. Make it quick.
I would really appreciate you considering granting this variance so that my wife and I can build the house of our dreams and retire here.
Thank you, sir. Close it, public discussion.
Motion to close.
Second.
Second.
All in favor, aye.
Aye.
Motion. Go ahead.
I'm sorry, but I'll make a motion to deny.
Second.
Discussion.
Yeah, I said in my earlier comments, when you haven't built it and you haven't got a final design, and I agree with you, you can find some way to build a house that will give you the view you want, I believe. And I'm not an architect, but I'll take your word for it.
Well, and I feel like they created the lots at the widths and dimensions they did, so they knew what they were dealing with or would have to be dealing with in the future.
I think you could actually come up with a house that's even better than the one that you presented to build if you work within the limitations of the lot.
Bill?
Yeah, I think you can still work within the setbacks and still have reasonable use of your land, so.
Charlie, you got 30 seconds.
I can kind of see that's hardship, but then, like I said, there's a good chance you could move it around and do something with it. I don't know.
We have a motion, we have a second. Mr. Burson, how do you vote? We have a motion to deny and a second to deny. How do you vote to deny?
Aye.
Charlie?
No.
Nay? Aye. Bill?
Aye.
Chip?
Aye.
Sorry that your request was denied. Do we have any others?
Yes, sir.
That concludes our agenda tonight.
We had a minute.
You have the minutes. Any corrections to the minutes?
Leave me alone.
Motion, motion to adjourn. Second.
Second.
All in favor, aye?
Aye.
What?
Time or two back. Yeah, they're nice. You don't like them, you can hear. They don't crackle, but you can hear better. Yeah.